morning, everyone. I'm Bill Traynor, the Dean at Georgetown Law, and it's my privilege to welcome you to our campus for the Right to Remain Children, Race and Juvenile Justice 50 years after Gualt. As you all know, in the seminal case in Re Gualt, in 1967, the Supreme Court affirmed the right to due process for youth accused of delinquency, including their constitutional right to defense counsel. But despite Galt's assurance of representation and despite its goal of fairness through due process, 50 years later, the overcriminalization of youth remains one of the most pressing problems in our nation's juvenile courts, particularly for youth of color. Today, we both celebrate the 50th anniversary of Gualt, but we recognize as well that there's still much to be done to ensure that youth of color receive their constitutional rights. And we're honored to host this symposium that will continue the transformative conversations that are required to combat racial injustice in the juvenile system. And this is a symposium that really echoes with our core principles at Georgetown Law. If you walk around the campus later, you'll see our motto is over the doors of the library: law is but the means, justice is the end. That's our defining principle. And because that's our defining principle, we're privileged to be able to host this event. And we're proud to be able to support Georgetown's Juvenile Justice Initiative and to support the mission of the National Juvenile Defender Center. Both entities that stand at the forefront of the national campaign to protect the interest of children involved in the juvenile justice system. So, on behalf of Georgetown Law, I welcome all attendees and presenters for what I know will be a very productive and important symposium, encompassing legal scholarship, policy advocacy, and training for current and for future lawyers. This event embodies our law school's commitment to social justice. So I'd like to just close by thanking all the people who made this possible. Our special events, communications and design team, AV team, facilities, Georgetown Law Library. All of them worked very hard to make this event come alive. I'd like to single out Erin Keith, who did so much to plan this conference. This is a long time in planning, and she did a fabulous job. And I'd also like to particularly thank Professor Chris Henning, who's such a visionary, such a leader, and who's so proud to have brought everybody together for our discussions today. Chris. And finally, I'd like to congratulate the Juvenile Justice Clinic and NJDC on hosting this great program. It's going to be a great day of discussion, and I'd like to congratulate you in advance. And I know that at the end of the day, we'll all be very proud of all of our conversations. So let me call to the stage Marianne Scally, the Executive Director of the National Juvenile Defender Center. Marianne.
Good morning. On behalf of the National Juvenile Defender Center, it's our pleasure to co-host this critical symposium on the importance of addressing the racial disparities in the juvenile justice system. On this 50th anniversary of the case that affirmed children's right to counsel, there is no more important conversation to be having than focusing on our continued violation of children's civil rights by the disparate enforcement of laws and affording them an effective right to counsel. So thank you so much for spending the time with us today. I can't thank Georgetown enough for making this happen. And we know this day is going to be filled with extraordinary conversations that we hope have an impact on the work that we all do. Thank you so much.
Tamir Rice, Laquan McDonald, Tyree King, and Jordan Edwards. This symposium is dedicated to these young people and to all African American youth who lost their childhood because they died too early. It is also dedicated to all children of color who find themselves overrepresented in the juvenile and criminal justice systems. It is for Dejaria Becton, who was tossed to the ground at a pool party in Texas. It is for Shakara, who was yanked out of her seat in a South Carolina high school for having a cell phone in class. As your third and final welcome, I come to you on behalf of the Georgetown Juvenile Justice Clinic, and I am honored to have you come and participate with us in this symposium on the right to remain children. As you have heard, In re Gualt was decided in 1967 in the heart of the civil rights movement. And although the case provided important due process rights for all young people, the promise of Gualt and the rehabilitative mission for juvenile courts across the country remains to be unfulfilled for many youth, especially youth of color. Today, 50 years after Gualt, youth of color continue to be disproportionately suspended and expelled, arrested, processed in the courts rather than diverted, detained in secure facilities, and transferred to adult court for prosecution. As stakeholders on the front lines, I cannot stand by and watch. All of us must stand up and fight against the criminalization of normal adolescent behavior in communities of color. We must all insist that children of all races have the right to remain children. In addition to the many thank yous that Dean Traynor issued, I cannot sit here today without giving a special shout out to Aaron Keith, as Dean Traynor did, for just doing a wonderful job of bringing this conference to life. I thank you, Aaron. I thank you to our partners at the National Juvenile Defender Center, who have led the charge in raising the level of practice among juvenile defenders for children of all races all across the country. I thank you to Dean Traynor and to Vice Dean Jane Aiken for their tremendous financial support and intellectual support for this endeavor today. I thank our wonderful alumnus, Agnes N. Williams, for her generous endowment that also made this conference possible. And finally, I want to acknowledge some of our local leaders who have stood up for racial justice right here in the District of Columbia and who will be coming throughout the day, including our presiding judge and deputy presiding judge of the family courts, Judge Carol Dalton and Judge Peter Krauthammer. I want to thank Judge Dalton for getting the word out in our community and encouraging our stakeholders to come. I want to thank the Metropolitan Police Department Youth Commander, Chanel Dickerson, for encouraging her team to come on today. And I want to thank our first elected Attorney General for his support, for his encouragement. And we look forward to hearing from him later this afternoon. And I want to thank all of you. Over 320 people have registered for this conference, and folks are still emailing as late as last night and this morning saying, can I come, can I come? The doors are open, and we expect for folks to flow throughout the day and engage. And so I hope all of you will be inspired to continue the fight, and I hope that all of you will be empowered with new ideas and new tools as we create some positive and lasting change for Black and brown children in this country. So we thank you. I am honored to start this conference with one of my absolute favorite people, one of my models, my inspirations, and that is James Bell, who is the executive director and founder of the Haywood Burns Foundation. So I'm going to call him up to start the conference. And his biography is in your program. I hope all of you have the program, because throughout the day, to save time, we're not going to do extensive biographies, but read and be impressed.
Professor, how do I advance the slides? Chris, how do I advance the slides? Professor?
Absolutely. And let me put your sign up. So this you can use either
Okay,
the
got it.
arrow or
Right there.
the
Got it.
thing.
Okay.
In case y'all forget who he is.
Oh, how cool is that? All right, thanks. So good morning, everybody. I too want to thank the fearless and tireless warrior women, Professor I hear now, Professor Kristen Henning and Marianne Scally for inviting me to start this symposium and address you this morning. I'm so grateful to be a part of this contemplation of N. Ray Gualt at 50. So there is very little in the human experience more fundamental than feeling safe. Fear is a powerful human emotion that informs so much of our personal and institutional behavior. And the justice sector is increasingly asked to solve problems that are often beyond its natural borders. In the recent Oscar-winning film, It Works, Moonlight, the central character, Chiron, endeavors to negotiate sexual identity, fear of bullying, trauma, and lack of parental supervision as best he can. The film depicts the claustrophobia and scarcity of options and resources in neighborhoods of concentrated and persistent poverty. Hey, John. In this case, Liberty City and Overtown in Miami-Dade. While enduring months of adversity and with no services available to him that he is aware of, Chiron takes safety in his own hands by violently attacking his major nemesis, breaking a chair across his back. Now, in the theater that I attended, how many here saw Moonlight and remember that scene? A lot. Well, I don't know, but in the theater that I attended, this attack was greeted with what felt like cathartic, spontaneous applause. People clapped when he broke the chair over his nemesis's back. Yeah, the little guy fights back. Don't let him punk you, Chiron. Punish that bully. Teach him a lesson. So many emotions I felt that were wrapped up in that applause. One, a testament to the power of great art. I believe that this powerful scene represents almost everything I want to explore in this short journey we are going on together about how race and ethnicity live in the administration of justice. Now, in this case, civil society will not allow you to just break a chair across somebody's back. So public safety demands a response. But that response lives in a context which is filled with the complexities of how race and ethnicity are lived in the real world. Because while Chiron won that momentary battle, those of you that saw the movie know that he lost the war for the types of services for wellness that justice should be about. And most likely would have gotten those services had he lived in neighboring Coral Gables rather than Liberty City. Public safety demands that his act of violence be redressed first, and whatever the social drivers are that prompted the attack will be relegated to low priority if addressed at all. So he's arrested, traverses the justice apparatus, sent out of state where he becomes a drug dealer, never able to address his sexual identity or trauma, with violations of parole shadowing him for the rest of his days. This tiny episode is an expression of the challenges facing the equitable administration of justice in all the 3,100 counties that comprise this country. So let's acknowledge, let's start here. I appreciate being able to start today, that there are two aspects of life where folk exercise entitlements and privileges in their daily lives. Those are where folks choose or are allowed to live. That's our first exercise. Next, where folks choose or are allowed to get educated. And when you look at those two things where people vote by their feet, not what they say, but where they live and where they send their kids to school, this country is as segregated now as it was when Gualt was decided, if not more. It's not colorblind in any way. So our choices are not colorblind, and neither are the institutions that reflect civil society's choices. This freedom of choice is undergirded by local policies and practices that the justice sector is called on to support and enforce every day. Inequities by race and ethnicity for the purposes of this gathering are deeply rooted and part of the structural fabric woven almost imperceptibly, but deliberately, by policies, practices that are born of discrimination. And try as some may want, the justice sector professionals and practitioners cannot isolate themselves from this reality. So the structures that form the foundation of our policies and practices that are deeply embedded in the fiber of your agencies perpetuate the often unspoken but deeply felt remnants of 3 centuries of social and legal norms that were constructed on the beliefs that young people of color were at different times, this is the legacy that we have, young people of color at different times were savages, feeble-minded, incapable of normal function, or not even human. So let's unpack this. Kristen asked me to do this history by documenting important events embedded in the administration of justice done at the larger society's behest. When one looks at the levels of violence, oppression, depression, substance abuse, and suicide amongst Native Americans, you often hear about historical trauma. Why does what seemed like an injury from over a century ago have so much energy for those of you working with urban Indians today or near reservations? Here is why. Look at how many children in this picture of Carlisle School were never parented, nor learned how to be parents themselves in the ways of their people, lost their language and cultural imperatives, while experiencing, on top of all of that, you get to experience physical and sexual abuse. Not to mention the psychic impact of social norms of justice and education institutions that reinforced in so many ways that you and your people are inferior. Kill the Indian, save the man. So it is naive to believe that services that paper over the pain and hurt that remains palpable in the here and now will be effective and enhance safety. It's naive. Similarly, the justice system has not been kind to Latino youth. The Whittier School in Southern California institutionalized and enforced a system of punishment based upon the racially informed emerging science at that time of eugenics. Eugenics claimed that criminal behavior could be predicted by race and body type. This was crime prevention. Also, brilliantly discussed in Mr. Mukherjee's book, recent book, The Gene. Some of you might know his work, The Emperor of All Maladies, about cancer. He's just written a book about the gene and has a chapter on eugenics, which I think are well worth reading. The implementation of this crime-fighting strategy fell hardest on Mexicans and Filipinos. Under this regime, youth whose brains were considered normal, that is, white, could be rehabilitated, while the youth found to be feeble-minded, Mexican and Filipino, were considered irredeemable. The punishment for those considered feeble-minded was incarceration in conditions that were terribly inhumane. So if your mind is feeble, then you should eat like a dog. And in many instances, people don't know this, resulted in sterilization as a crime prevention technique of thousands of boys, Mexican, Filipino. Again, if you think this is ancient history, I point out the salience of the work at Harvard University's Wilson and Herrnstein's significant influence on justice policy and legislation with their work, Crime and Human Nature. Similarly, Asians have experiences which took them from families at young ages to assimilate them as well. The Ming Kwang home, where I'm from, in San Francisco. And this statute wasn't called the Exclusion Act, it was called the Chinese Exclusion Act. So people knew what the deliberate nature of this. Finally, black youth and communities have borne a significant brunt of state-sanctioned inferiority and violence. Beginning as enslaved people with no regard for childhood or humanity, the Negro, a beast in the image of God. That's what you do when you say people aren't human, but on Sunday, you have to say, oh, these are our religious teachings. That is serious pretzeling to do. To the first segregated houses of refuge in the North, 1824, New York, to elaborate convict leasing that included children, as you can see here, to the execution of 14-year-old George Stinney, the youngest boy to be put to death in the mid-20th century, to the Central Park Five and the myth of the super predator, it is no accident that folks in the black community are claiming that Black Lives Matter. The point is, there is a historical common theme that is a recitation of a painful reality of state-sanctioned and judicially enforced grievances that still live in the hearts of mind of many communities of color, which has them suspicious of the larger society's grand bargain for safety. Nothing just happens regarding important life options, and civil society provides the values that fill the reservoir, which is the source for the tributaries that are supposed to wash over us equitably. For some of us, this notion of structural racism and the cultural hegemony that it makes is the American norm has not been in the periphery, but is front and center. For others, it is becoming clearer and nearer and harder to ignore, as Kristen just said by announcing those names. Let us take this opportunity to clarify that communities of color may not say it in broader conversation, but communities of color understand where hegemony and power leave them. So while folk deny how we got here, using the privilege of willful ignorance, being willfully ignorant is a privilege that structural racism allows. The knowing is the knowing. Or as one hip-hop song said, because if you don't know, now you know. Clarity and proximity present opportunities to no longer excuse the deliberate decisions made to keep us in segregated neighborhoods. Now, I didn't bring a slide from Mississippi. I brought a slide from the progressive Bay Area. This is Rock Ridge, a neighborhood well-desired in the Bay Area. All the legal aid lawyers live there, the judges live there, the DAs live there, the public defenders live there. It's a nice neighborhood. But you can see from this real estate slide, the arrow points to Rock Ridge Park when it was just being developed. No Negroes, no Chinese, no Japanese can build or lease in Rock Ridge Park. And today, that neighborhood is 75% white. Attending underperforming schools, you can see the data. White kids go to school with white kids, kids of color go to school with others. Having less access to medical and healthier options. This slide comes from our colleagues at Robert Wood Johnson. If you look at the lifespan in Blue Hills, it's 69 years old. 3 miles down the road in Armour Hills, it's 83. That is the lifespan difference, 3 miles down the road. And I would say to you people, that ain't because of secondhand smoke, okay? These are the policies that we live with, and the police being the dominant face, and sometimes, unfortunately, the only face of government. So the impact on the psyche and the soul of negotiating the mores and dictates of too many communities that populate the justice apparatus raises the question, does the justice sector have any responsibility for the health of communities with entrenched income inequality and deeper marginalization evident in every walk of life? So when I show slides close to home to say, don't pick on the people that are easy to pick on the people that are supposed to be progressive. That's my town, San Francisco. It's giving you Twitter. It's giving you Uber. It's giving you Lyft. We can go on with all those things it's giving you. This is the Alice P. Griffith homes. I bet you 90% of San Franciscans have never seen it, have never been there. If you look, you can see speed bumps, one way in, one way out. 3 bumps on one side, 3 bumps on the other, that's it. What parent is going to send their kid to a quinceañera in that place? What kid's going to say, hey, you want to come home and have a party at my house? You want to have dinner at my house? What kid's going to say, and what's your address? These are the evidence of deeper marginalization every day. This is Freddie Gray's neighborhood. What are the rules when there's 51% unemployment? The knowing is understanding that fear is powerful and rarely susceptible to reason and logic. And fear looks like us to many of those who make decisions about us. The knowing is a new narrative born of 40 years of living in communities where the moral arc has not and is not bending towards justice. The knowing is to beginning to hear the uncomfortable truths about us all. In my capacity as the director of the Burns Institute, I've had the opportunity to work with community folk, defenders, health professionals, school officials, law enforcement, judges, you name it, in a bunch of counties and a bunch of states. Regardless of will, because folks have been grappling with racial and ethnic disparities now for years, I'd like to pose at this symposium there's a major conundrum in the justice, human service, equity space that must be overcome, and I believe in most of the counties in this country, like, 3,000 of them, they just can't get there. They can't get to what they need, and the reason they can't get there is we as civil society allow them to not get there. It is a fundamental bedrock principle that the justice apparatus, this is the fundamental principle, the justice apparatus must never concede ground on being anything but race neutral and colorblind. That is the bedrock. The iconography is justice with a blindfold on. So no justice apparatus will ever concede anything but race neutral and colorblind. My experience in so many jurisdictions encountering folks, my colleague Mark Soler is here, we do this work, this is what we hear all the time. I don't see color, or I only deal with the files or people in front of me. I am always torn when I hear this because I know that these folks are speaking from experience and don't make race-based decisions in the way that I'm suggesting. However, there are too many instances of lived experience that belie this important American fable. So those people that say, I don't see color, that's an American fable because nobody's going to say your first speaker today was a white woman. What you're saying, that's a proxy for I'm not a racist, but you do see color. So the point is not that our justice apparatus and its participants are de jure racist, but it necessarily raises the question about what it is in the American experience where race lives so deeply in the institutional fabric, but yet is never specifically admitted. And in the justice sector cannot be admitted. So the fundamental question that we have, those of us that care about this, is how do we engage a problem that people say we don't have? That is the big question. How do you target racial and ethnic disparities in a judicial apparatus that will never admit to being anything but race neutral? How do you overcome that? In order to be successful, we at Burns suggest that traversing, give me 3 more. Can I get 3 more? Can I get 3? Okay, 3. In order to be successful, we at Burns suggest that traversing the first hurdle is not about ferreting out racist actors. It is about deconstructing racialized structures. It's deconstructing racialized structures by having a fierce culture of inquiry about practice. Indeed, even changing the face of who is in power does not inherently alter how structural racism manifests itself in the justice context. As author Khalil Muhammad points out, we now live in a post-assimilation America. We cannot engineer a more equitable nation simply by dressing up institutions in more shades of brown. And that would be the case. If you're in Cook County, the police officer arrests you is black, the DA that prosecutes you is black, the indigent defender that defends you is black, and the judge that sentences your ass to jail is black. We must hold 2 seemingly opposing truths in our heads and hearts simultaneously. We must do the important work of motions, briefs, and courtroom tactics. However, we must also imagine and manifest ways to address the structural context of those living in neighborhoods of rural areas of persistent poverty and captives of the emissaries of custody, control, and suppression. So, resist the seductive demands for instant solutions. There are no quick fixes in the offing, and anybody that tells you there is one, don't trust them. Today's Gualt-like challenge is understanding how our deeply embedded explicit policies and practices operate in a supposedly race-neutral pursuit of safety and order. So this today, and thank you, organizers, Kristen, Marianne Scally, and Georgetown, provides another opportunity for ideas, contemplation, insights, and energy to move us to face our new challenges just like those lawyers did 50 years ago. Like them, we must challenge current orthodoxies by using creativity, case law, dicta, art, and powerful ideas to fight the idea that deprivation of liberty for too many youth of color is not a 21st century caste system. So, I thank you for your time, and equity demands that we be creative in order to change the balance of power regarding decisions about who will be the keeper and who will be the kept, who will be the servers and who will be the served, and who will suffer abuse and who will be protected from harm. Thank you very much.
Thank you so much for setting the stage, James. It is essential as we think about how to move forward on this question that we continue to look back. And as we move forward, I would like to call to the stage all of the panelists for the next panel on implicit bias. And as the panelists are coming up, we are going to precede that panel with a word about implicit bias and the criminal justice system from Devin Carbato, who joins us from UCLA. And I'm very excited to hear from him. Devin is long been known as a thought leader on race, law, and police violence. And so we very much appreciate him coming all the way from California to talk to us. Thank you.
So thank the organizers for conceiving of this event and for inviting my participation. It really is a treat to be here, and I'm looking forward to your comments, your questions, and your overall engagement as I discuss what I'm calling Implicit Bias 101. I should start by saying that part of my formal title at UCLA is that I'm the Associate Vice Chancellor for Brewing X. And Brewing X is the research and development arm of the Office of Equity, Diversity, and Inclusion. And my team looks something like this. I have a program coordinator, Brandy Kirkpatrick, 2 research scientists, Carly Strait and Evelyn Carter, and a special assistant, Jonathan Feingold, who is also a lawyer. Heading our office is Jerry Kong, and I want to highlight Jerry Kong in part because for over the past 15 years, he has been pushing a conversation about implicit bias under law to just about anyone who would listen to him. And in a way, he is, I think, one of the leading thinkers on the intersection between law and social psychology, and more specifically, law and implicit bias. I want to begin our conversation about implicit bias not by defining what it is, but by asking the so what question. Why might we be concerned about implicit bias to begin with? Well, one answer is that implicit bias shapes how we see people. A more fundamental response is that implicit bias shapes how we treat and evaluate people. So these are reasons why we might be worried. But I want to pause for a minute, and it was helpful that James began in the way that he did, to suggest that implicit bias isn't the whole story. Indeed, it might not even be the most important story. I'll presume to say, though I'm not a juvenile justice scholar or thinker in any deep way, that the problem of juvenile justice is a structural one, and that it's easy to go to implicit bias as perhaps a palatable way to make sense of these structural problems. So I want to have us think structurally for a minute by having us engage this particular image. So it's not a picture of people, it's a picture of cows. So I'm a board member of the African American Policy Forum, which is an outfit that Kim Crenshaw and Luke Harris started more than 2 decades ago. And we sometimes show this image, and we ask the following question against the stipulation that the cows are sick. So the cows are sick, and then we ask, why are the cows sick? If I had time, we would engage in a conversation about this. But typically, we get 2 kinds of responses. The cows are sick because of something the cows are failing to do for themselves. The cows are sick because they're not eating properly, they're not drinking properly, they're not pulling themselves up by their bootstraps, let's say. In other words, it's something about what the cows are doing to themselves or are failing to do for themselves. Then we get another set of responses that focus now on the farmers. So it's about the farmer's relationship to the cows. The farmer doesn't like the cows. The farmer is a cowcyst, analogous to a racist. So you get the idea. 2 kinds of responses. One set of responses focus on what the cows are failing to do for themselves. Another set of responses focus on the farmer. If I pull back the frame, we begin to see that the cows exist in a toxic environment, which is to say, quite apart from what the farmer might be doing to the cow, and quite apart from what the cows might be doing to themselves, the cows are going to be sick. This is what it might mean to think structurally about the situation in which the cows find themselves. This is not to say that we're unconcerned with whether or not the farmer is a cowcyst. Clearly, that matters. It's not to say that we're unconcerned with whether and to what extent the cows might be exercising poor choices under constraints. We're worried about that as well, but we're also concerned about the structural frame. So notwithstanding that I'm going to be talking about implicit bias, I think we need to keep in mind precisely what James Bell urges us to think about, which is to say the extent to which we might be confronted with a particular structural problem. With that out of the way for now, let's talk about implicit bias. And I'll follow something like the following roadmap, talking about implicit bias and its relationship to schemas. Then I'll move on to consequences, and likely I won't have time to get to countermeasures, so we can think about that in the Q&A. So our brains are on autopilot. I think you might all understand what that might mean. Our brains have to be on autopilot. We don't have enough cognitive resources to think consciously and intentionally, to act deliberately and purposely as we navigate the social world. Therefore, we have to think in terms of heuristics, in terms of mental shortcuts, in terms of templates of knowledge. So that sounds terribly abstract, so let's try to make it more concrete. If I show you this particular image, you automatically go to, it's a chair. You don't think it has 4 legs, it's made of wood, it has a seat. You go to chair right away. More than that, you begin to form a set of associations with respect to what activities you might do with a chair. So you might sit on a chair, you might nap on a chair, you might stand on a chair. And these associations have different levels of strength. That is to say, sitting on a chair might be more strongly associated with a chair than napping on a chair, except perhaps when you're grading exams. Napping on a chair might be more strongly associated with a chair than standing on a chair. You get the idea, I think. So let's move from chairs to people. So this is a picture of Paul Butler. I'm not sure if he's in the room. I'm not going to tell you what comes to mind when you think of Paul Butler. But what I will say is that, similar to the categorization that I just described, a series of hashtags are going to appear, right? So we're thinking millennialism, hashtag male, hashtag black, hashtag tall. These are all automatically triggered. That's the relatively easy part. But then attitudes are formed implicitly based on those particular hashtags. And by attitude, I mean roughly positive or negative associations, like or dislike, thumbs up or thumbs down. That's roughly what we mean when we speak of attitudes. And then there are stereotypes. And there are a number of stereotypes about which we might be concerned vis-a-vis the hashtag black and male and tall. So is the person lazy? Is the person dangerous? Is the person a dancer? Is the person athletic? We are worried about stereotypes in the context of law quite clearly because of the extent to which they mischaracterize groups and mischaracterize individuals. With respect to these particular stereotypes, Paul might well say, well, let's get rid of two of them, but keep these two. Well, I have it on good authority that none of these really apply to Paul Butler, notwithstanding what he might say, so we'll get rid of all of them. The broader theoretical, I'm sure you do, and I'm not going to look at you as I resist your objection. What I want to say is that the broad theoretical point here is that this particular embodiment triggers the hashtag black, male, and tall. That triggers attitudes and stereotypes, and that shapes how we see, treat, and evaluate people. That's the basic insight. Now, it's another moment in which I want to pause to say that implicit bias isn't the whole story. I began by saying implicit bias isn't the whole story for structural reasons. Now I want to say implicit bias isn't the whole story because explicit bias matters as well. We too quickly sometimes move to implicit bias without taking seriously the fact that explicit biases still exist. And one way to think about the existence of explicit bias is to, again, take seriously the distinction between attitudes and stereotype. So here's what I mean. We might like African Americans, an attitude, but think that they're intellectually inferior, a stereotype. We might dislike Asian Americans, an attitude, and think that they're intellectually superior, a stereotype. Now, if I were talking to a group of freshmen at Georgetown University, and I say, okay, how many of you think that Asian Americans are smarter than African Americans? How many of you think that? No one's going to stick their hand in the hair. I mean, that would be the person that says, look at me, I'm the racist who thinks that Asian Americans are smarter than African Americans. That does not mean that no one thinks that consciously. That simply means that no one is prepared to articulate that aloud. In other words, we have lots of conscious stereotypes about people that we don't own. So it's important that we not consider that implicit bias. That's explicit bias, pure and simple. And there are a series of studies called bogus pipeline studies where you tell people, I have a pipeline to your soul. So if you're lying to me, I'm going to figure it out. When you wire people up to this particular machine and you say, I can figure out if you're lying, they say an awful lot of racist and sexist things. So the point, again, is that let's think about implicit bias to be sure, but let's not forget that structuralism matters and explicit bias matters. So this is the moment in which I'm going to ask for your collective participation. It's an implicit bias test, but to think about Tina Turner, you know, Proud Mary, where you start nice and easy. We're going to start nice and easy by thinking not about race, but about colors. So here's the basic idea. I have a series of columns. So if I were to say, tell me the colors, in column 1, you would say green, red, purple, green. Column 2, blue, yellow, blue, red. So column 3, this is you. So shout out column 3, the colors.
Green, red, purple.
And shout them out like you're committed to juvenile justice. Let's do it again. So column 1, loudly.
Green, red, purple, green.
Column 2.
Blue, yellow, blue, red.
Column 3.
Green, yellow, red, purple.
I promise this is the last time. Column 1, colors.
Green, red,
Colors,
purple,
column
green.
2.
Blue, yellow, blue, red.
Yeah, so
Strip test works good.
I just want to say I hope there isn't a relationship between how well you did here and your juvenile justice advocacy. That's all I want to say. But I think you get the idea. When concepts match, right? When they match, that's grease. It's easy for us to do it. We fly through them. When they mismatch, that's grit. It slows us down. So identifying the color red in the word red is relatively easy. So part of what the implicit association test does is measure our reaction time to a certain set of associations. So to make that slightly concrete. So identifying black as good, that's like identifying the color red when it's in the word green. That's grit for us. We can't really do it that easily. Identifying black as bad, that's like red in the color red. We fly through that. White as good, again, identifying the color red in the word red. White as bad, you get the idea. Identify the color red in the word green. And the point is that this reaction time differential between how you might identify white as good and black as bad is the implicit bias space. And we can talk more about whether that measurement is seriously, but we should understand conceptually what's going on. We don't need to turn to implicit bias, though, to understand this point about scheme consistency and scheme inconsistency. These images, you recognize them? Yep. Mm-hmm. So you remember the captions? Yep. So black people are looting and white people are finding. If you flip the script, as it were, it doesn't quite work as comfortably, precisely because of pre-existing notions, pre-existing social meanings that map onto race. So I want to talk about implicit bias in another way. I've talked about the implicit association test, which measures reaction time. There's another way in which you might think about implicit bias that has to do with priming. So in this particular study, Jennifer Eberhardt and her colleagues had participants identify two kinds of objects. A crime irrelevant object, that's an iron. I always have to stress to my students, it's not some archaic thing, it's an iron, it's useful, it's still useful. And a crime relevant object like a handcuff or a gun, you get the idea. So subjects were primed with white male faces, black male faces, or no faces at all, meaning they're sitting in front of a computer screen and they don't know that they've been exposed to a particular set of images. White faces, black faces or no faces at all. And then you have to, again, identify these two objects, a crime-related object or a crime-irrelevant object. And the difficulty is that the objects appear before the participants at different levels of degradability. So if I showed you this image, for example, you might not be able to identify what it is. Maybe you can see it now at frame 25. By frame 41, you can clearly see that it's a gun. So the question is, at what frame do you identify the gun as the gun or the iron as the iron as a function of being primed with a white face, the black face, or no face at all? You all follow the basic idea? So these are the results. So focusing first on the crime irrelevant object. So we're talking about the iron. You'll notice that there is no difference with respect to when participants are able to identify the iron as the iron. In other words, it doesn't matter whether or not you're primed with the white face, the black face, or no face at all. You identify the iron at roughly the same frame. With respect to the gun or the handcuff, the story is really quite different, and it's different in a profound way. To put the point this way, when you're primed with a black male face, that facilitates your identifying the gun as the gun or the handcuff as the handcuff, right? You identify it at frame 18, basically. With respect to the white face, you'll notice that being primed with whiteness inhibits your capacity to identify the gun as the gun or the handcuff as the handcuff. So the authors conclude that there's an association between black and crime. When you prime people to think about blackness, they think about crime. But there's a bidirectional relationship as well. So when you get people to think about crime, and the authors demonstrate this empirically, they're thinking about black people. And this study significantly included police officers as well. 2 more studies and then I'll stop. In this particular study, the authors are interested in not just biases and stereotypes, but also problems of dehumanization. And this again relates to the point that James Bell was suggesting, which is to say the extent to which African Americans have been perceived to be subhuman. So they tested this in pretty much the same way. Again, they primed people with black male faces, white male faces or no faces at all. And this time, what they ask participants to do is tell us when you can identify a big cat, so a lion, a tiger, not a bear, when you can identify a big cat as a cat, or when you can identify the ape as the ape. So that's what people are now being asked to identify. So again, here are quickly the results. So with respect to the big cat, right, and remember, the big cat appears before the participants at different levels of degradability. When can you figure out it's a big cat? Doesn't matter whether or not you're primed with a white face, a black face, or no face at all. You pretty much identify the big cat at the same frame. With respect to the ape, the results are not pretty. So primed with the black face, you identify the ape pretty quickly. Primed with the white face, that again is an inhibitor. The final study that I want to make bears directly on the question of juvenile justice and innocence. So this is a study by Phil Goff et al., and they're trying to figure out to what extent do black adolescents have a right to remain adolescents. Here are the basic findings. They find, not surprisingly perhaps, that black adolescents are perceived to be less innocent, A. B, that we overestimate their age. This is profoundly significant, which is to say we overestimate the age of black children, particularly when we perceive them to be felony suspect, by 4.5 years, which means that black adolescents are effectively adults at the age of 13.5. We perceive them to be more culpable, that's the C. Again, we associate them with apes. And this study, too, included the police officers. So it's not just effects that manifest themselves vis-a-vis students in colleges. It also is the case that these particular biases and problems manifest themselves with police officers. So let me conclude by again saying that we surely should be thinking about implicit bias, but I worry that oftentimes we tell ourselves in a kind of Kendrick Lamar sense that recognize implicit bias and it's going to be all right. It's not going to be all right. There are a range of structural problems that we have to deal with. A, we need to recognize that explicit bias is a part of the scene. And, you know, this moment of Trumpism should make clear that explicit bias has not disappeared. So if all we do is have a conversation about implicit bias, I think that's important, we lose the opportunity to engage in hard conversations about the way in which race is structurally embedded in the juvenile justice system as it is in the context of criminal justice arenas more generally. So let me stop there. Thank you very much.
Thank you so much, Devin. That was very insightful. And we're going to call up Dr. Bowman Williams, a professor here at Georgetown, to moderate our next panel. Thank you.
Thank you, and good morning, everyone. So I do appreciate that was an excellent overview you gave us, Professor Carbato, of implicit bias, how it works together with both explicit bias and structural bias. And now I'd like to think more about, so we got an intro to how it may work in the criminal justice system. So now I want to think more specifically about that based on some of the experience we have from our panelists, as well as how it may play out and shape some of the outcomes we see in the criminal justice system, in the juvenile justice system in particular. So one thing I just want to start out to frame our conversation here is that some of us may think that implicit bias and some of these explicit biases are issues of others, so other stakeholders. So this is an issue that the police are dealing with or that we see happening with judges, but we don't always reflect and think about the biases that we personally may hold. So that's one thing that I want to start us out with, and just think about how it may affect public defenders, prosecutors, and some of the other folks who may advocate for some of the disadvantaged youth in this system. So let's start out with the defense attorneys, which may be arguably one of the least obvious groups. So these are the folks who do advocate and represent some of these youth in the system. So let's start out by discussing how implicit bias can play out there, starting with Professor Edkins. So you do some research in this area, more specifically about how implicit bias among public defenders can affect the plea negotiations that happen. So can you just begin by telling us a little bit about your research and what you found there?
Absolutely. My mic on? Okay. Thank you very much for inviting me to this. I think it's a really important discussion. I'm glad we're having it. So some of my research, I focus mainly in the area of plea bargaining. And I wanted to look at defense attorneys in particular because sometimes legal scholars write about how when it comes to bias in the legal system, lawyers can be the de-biasers. Lawyers can be the advocates and help to reduce some of the bias that might be present. But we know that the disparities are so huge in the legal system. It can't just be because of policing. It can't just be because of juries, right? And so I wondered whether or not those advocates also were contributing to the issue. And so I looked at defense attorneys and their plea recommendations. It was an experimental design where defense attorneys were given case summaries, and for half of the attorneys, the individuals depicted were black. For half of the attorneys, they were white. And I also varied the strength of the evidence. And I basically asked the attorneys, I wanted to know, okay, so if the prosecutor has approached you with a deal, what is the best deal you think you could get for your client? And I also asked them kind of at what costs should your client avoid trial sort of questions. So, this is the best deal you think you could get, but what if the prosecutor won't budge? What is the maximum you would recommend your client consider accepting if they were offered? And I did find distinct biases. I found that when it was a Caucasian client, they were less likely to settle for a plea that would have jail time attached. And I actually found that race was stronger than strength of evidence. So with the African American clients, they were more likely to settle for a worse deal and significantly more likely to recommend a deal that did include jail time. So the bias is there, and one of the reasons I thought it might be reflecting something somewhat implicit, I also asked them some questions about how they thought their client would fare if it did go to trial, because perhaps this is a recognition that, the jury system is biased, so I've got to avoid that at all costs, and this client would be better settling. So I actually asked them about their perceptions of actual guilt. Do you think this individual is actually guilty? And I asked them about how they thought their client would fare if they went to trial. And I didn't find differences there. So they were just as likely. I actually had two samples, and some of the Florida attorneys, that's where my research was stationed from, were more likely to say that basically that their black clients should be avoiding trial, and I've got other data from Florida that supports that too. But they were basically feeling that across the board they were equally likely to be guilty, and that their chances at trial would be about the same. So it's not that they thought they were saving their defendant from something. It was more likely manifesting or showing something that is more unconscious or implicit, something that is driving their decisions that they don't necessarily have control over or a complete understanding of.
All right, that's fascinating. So, yeah, it would be easy to say, well, maybe that's not their biases. They're just perceiving these broader structural biases that they're reacting to. But you seem to disentangle that, which is very interesting there. So that gives us the empirical and more of the scholarly perspective on it. I want to talk more about how it may play out day to day. So moving on to Ms. Pruski, you are a public defender. So you see how this may manifest daily in your office. So I'd like you to just maybe touch on whether that seems to reflect what you see day to day, or in what other ways may you see implicit racial bias come up in your work.
Yeah. Thank you. And it actually doesn't surprise me to hear what Dr. Edkin's research shows or study shows. I think when you talk about public defenders, I think a place that you have to start with is kind of how the question was posed: is public defenders? No way, not us. You know, we're against anything that has to do with injustice or unfairness. So clearly, we aren't biased, and that's a problem, right? Like if public defenders start there, that is a problem. And studies even show that when you sort of deny that it exists, that it totally gets in the way of becoming aware of our biases and actually doing something about it. So, so how does it play out on a day-to-day basis? It plays out like even before we meet our clients. When we're reviewing the criminal complaint, we're oftentimes we know the race of our client before we even meet them, and already we're forming judgments in our mind about, well, I think this person's probably guilty, and I think that, their admission is probably the truth, or whatever. And so, so it plays out there. It plays out, I think, a lot when we're interacting with our clients, and we don't even realize how it's playing out. So, for example, questions that we might ask our client, asking a white client, do you have any children? Asking a client who's African American, how many children do you have? Things like that I think oftentimes we don't even know we're doing unless, it's pointed out to us, or we're willing to acknowledge that, that this is happening. How much time we spend with clients, how close we sit with clients. Are we sitting further away? Are we sitting closer to them? What are we thinking as our client is talking to us about their case? Are we believing what our client is telling us, or are we not believing what they're telling us? The plea negotiations, how hard are we fighting for that client when we're, talking to that prosecutor about how to resolve the case? The resources, that we put forth in different cases, are we asking an investigator to get involved in this case? Are we spending more time on this case versus that case, or for this client versus that client? Thoughts that go through our head, like, and I've had defense attorneys even admit this to me, or admit this, that, when they see the white client, in the courtroom getting ready for their bail hearing, they notice this thought goes through their head, like, oh my gosh, he doesn't deserve to be here. Whereas maybe the African American client, maybe what's going through the defense attorney's head is, well, another conviction isn't going to matter. Serving time in jail isn't going to matter, and these are all ways that it can play out in the defense attorney's mind and practice, and it's a scary thing. And I think what we have to do is, and I'm sure we'll talk more about this later during the panel discussion, is, having these thoughts doesn't make you a bad person, it makes you human, and we have to acknowledge that they're there, and then we have to do something about it, so.
Yeah, definitely. So just going back to Professor Carbado's point earlier about this combination of the implicit, the explicit, and the structural, we know that one thing that does exacerbate the implicit biases are when we have a shortage of resources, a shortage of time, when there's a time crunch, and we know that many of the public defenders are overwhelmed with very heavy caseloads, et cetera. So can you just talk about how those may combine to make the issue worse, or maybe what you think the relative impact of the structural versus the implicit issues are in the public defender's office?
Yeah, so Song Richardson wrote a fabulous article, I think it was in the Yale Law Journal, I think it's a law review article, about comparing basically public defender work to emergency room work, and how public defenders are performing triage, right? We have to make really fast decisions about, where we're going to put forth resources, what are we going to do in this moment for this person versus that person. And so the conditions are such that, the way I like to think of it, and Professor Cardova, you talked about Devin talked about the, thank you, about the fast thinking, and how, the way I kind of like to think of it is the implicit bias kind of lies in our fast thinking, that automatic or that autopilot thinking that we have to do on a day-to-day basis. And that is kind of the life of a public defender. We're making really fast decisions, and we sort of decide on the spot, like, where we're gonna, make that argument or hire that investigator to work on that case. So, so not only, the conditions, the limited resources, the limited time, the extremely high caseloads, sort of like everything is working against us, right? Like, the case law is against us. People don't often understand what we do as public defenders. All of that combined with the fact that we are humans and we're, we have that fast thinking, and we are, we have those implicit biases, I think just combined, make it a lot more difficult to ensure that they don't get in the way of how we're, working with clients and working on cases, so.
Okay, and we're going to get to strategies in a few, so I'd like to touch back with you on that at that point. But let's move to prosecutors. So we have Adam Foss and Wayne McKenzie, who are both former prosecutors here on our panel. So I want to talk to you some about how implicit bias may arise among that group of stakeholders. One source of pushback we sometimes hear is that implicit racial bias is an issue of police mainly. So the greater targeting of minority youth or the higher arrest rates, it starts further upstream, right? So the question is whether you agree with that perspective. Is it that prosecutors do just simply get the cases that come in front of them, and then they have to apply the legal facts and apply the legal rules and assess the merits of the case? Or is there more of a combination of the policing and what happens at the prosecutor stage? So let's start with Mr. Foss.
Thank you, everyone, for being here. Shame on the people that aren't. So this is like, if you look around the auditorium right now, this is the problem. I mean, one of the major problems with implicit bias is, like, I saw all you people out at the bar last night. I know who's here and who's not. And for people not to show up this morning because they're like, oh, implicit bias, I'm good, I'm a defender, is a major driver of the problem. You are not absolved of implicit bias simply because you took a job after law school that makes you believe that somehow you are above bias. And this is true of prosecutors because we come into this job and we say things like, it's the police's fault, or it's the school department's fault, it's not my job. Literally the only job description I ever got was to do justice. And if that means processing cases without having sort of a veil on that says, all right, if I'm getting a disproportionate amount of young people of color, then part of my job is to recognize that and do something to remedy that. If that's talking to the police departments, talking to the school system, if that's talking to other prosecutors in my office, that's part of the job description. Like, doing justice is making sure that that doesn't keep happening. And the same sort of flaw that Gina was talking about in terms of public defenders thinking, no, it's not me. It's prosecutors have the same thing where we just think because of this job that we have, we don't see color. And I'm glad that James brought up the colorblind commentary today, because that's the pushback you get from almost every DA. We don't pay attention to it. We don't see it. And that is a major problem. You should be seeing it. You should be counting it and analyzing it. What does it mean to you? Because if you are not, then you're not doing your job of justice. And just one visit to a courthouse, one visit to a juvenile detention facility will be all that you need to know in terms of whether or not we're doing a good job or a bad job on protecting those young people from all of our biases: the police, the school department, the public health department, the prosecutor's office, the judges, the probation officers, and all that. So I would be really interested to hear what Wayne thinks about this. I don't know that we have much more to add that's different about prosecutors than it is for everyone else.
Yeah. So first, let me start by saying that Dr. Cabato gave my lecture, right? And to talk about my own implicit biases with accents, you sound a damn sight more intelligent and effective than when I do.
This never stops. Why do people black guy with an accent? I don't know.
And so, yeah, I agree with Adam. Let me start by saying prosecutors are the most powerful actors in the criminal justice system with the least amount of oversight. And if I had $1 for every time a prosecutor said, you know, it starts upstream, or I don't look at race, I would probably be vacationing somewhere instead of here today. But let me give you a perfect example of how it plays out in reality. When I was with the Prosecution and Racial Justice Program at the Vera Institute, I was working with a number of jurisdictions. So in one jurisdiction, the demographic of defendant that had the most disparity were actually African American women charged with drug crimes. 100% of the time their cases were accepted. 100% of the time, whatever the arrest charge was, that was the file charge. And they tended to stay in the system longer than anyone else. So when I showed this to the senior leadership and we had a conversation about it, I got every single justice-related excuse to explain it. But we'd actually controlled for every single justice-related excuse that they put forward. And so no one ever talked about race. Well, one person said something really negative. I used to talk about it, but I've stopped because it's a little shocking. But when we went back and looked at the data 6 months later, merely because we highlighted this issue, in 6 months, that disparity disappeared. So when you talk about justice being blind, that's only in theory, because you better believe that once they knew we were looking at this, they paid attention, and all of a sudden, I'll emphasize it again, that disparity just evaporated in 6 months.
That's a great example there. So that gives us an idea of how some of these strategies, so whether it's analyzing data or making the prosecutors more aware and adding in a bit of accountability, can make a big change and make a big difference in the outcome. So let's just talk a bit more about that, because Mr. Foss, you mentioned as well just this idea of doing justice and counting and analyzing and the example of the awareness. What other strategies, so outside of dealing with the police and what happens before it gets to you in your office, any other ideas of how you can do justice better or bring greater awareness or create sometimes some type of change in outcomes by dealing with other prosecutors?
So the craziest thing, when I started my job, the first day that I started, I worked in a neighborhood called Roxbury in Boston. And I had never been to Roxbury in Boston, even though I grew up in Boston, because it was the place that you weren't allowed to go as a kid. And I was surrounded by a class of prosecutors. There were 12 of us who started in Roxbury that year. 11 of those folks had never been to Roxbury before. 11 of those folks had never been inside of a jail or a prison. I would venture to say more than half of those folks had never interacted with a black person, young or old, in their entire lives. They certainly had never interacted with someone who was poor enough to sell their body to survive, someone who was poor enough to steal to feed a drug addiction, someone who was mentally ill, someone who was homeless. They hadn't had those experiences. And therefore, what they were left with, these 23, 24, 25-year-old young people on the line in a very busy courthouse, was their life experience. And when your life experience is going from your wealthy or affluent or upper middle class neighborhood to high school that looks the same, to a private college, to a private law school, and you walk out of law school equally prepared to be a tax attorney or an entertainment lawyer or a civil rights attorney, and you just take this job that endows you with this incredible amount of power that is unrestricted, you're setting yourself up for disaster. So that's a long way to say that we have to start thinking about, and it's interesting where we are now in law school, we have to start thinking about what are we teaching law students who are going to go out and do this work. Like, I didn't need to know the rule of perpetuity to become a prosecutor, and yet that was the bane of my existence in law school. Never once never once did we like go to an after-school program and learn something about youth of color and what was bringing them to the justice system. And yet there I was that first day making really, really grave decisions about people and looking at the folks around me who literally had never even been on the public transportation system and watching what that did, just based on that life experience, what outcomes kids were receiving. Because in their minds, they were filtering everything through their life experience with no regard for, hey, this kid might be carrying a gun because he's afraid, not because he's a killer. And when we divorce ourselves from really like, what does it mean to be a prosecutor and be a defender? How are we going to shape our law school curriculum? What is training going to look like when I come to the DA's office or the public defender's office? Why am I spending all of my time learning about how to try a case when the amount of time that I actually try a case is that much? That's how I think that we can start to peel back on these issues of bias, is just exposure and apprenticeship and really like making law school less of a business and more of an educational opportunity so we can go out and do the jobs we signed up to do.
Mm-hmm. Right. Yes. And I'll just add, so that type of exposure that he's talking about has been shown to change both implicit biases and explicit biases. And it may be something that we get in law school, it may not. It may happen in our training, it may not. But that's something that we can each do individually as well. Go get some more exposure, volunteer, mentor a child in the community that you're working with. Go get some exposure somehow and encourage others who you work with to do that as well. And that's something that can go a long way in changing the way these biases play out. So, okay, so let's then move on to talk some about judges. So we don't have any judges on our panel, so I'm going to ask Dr. Carbado to talk, or Professor Carbado to talk about the judges. Can you maybe just speak some to how you think implicit racial bias can affect judges' decisions and how they interact with or how they see things based on who's coming into their courtroom and how that affects their ultimate judgment of the different cases?
Yes, so I'm not sure how much insight I'll have into this particular question. I will say that there are a number of different contexts in which one might think about judicial decision-making. So I teach constitutional criminal procedure, and in that context, one's always grappling with what happens in vis-a-vis suppression motions. And one can just think quite obviously about the ex-post bias that exists. So the black guy and the drugs. I mean, are you going to suppress that evidence? Chances are not. And to what extent might bias be operating in that particular instance? I want to back up just a minute to riff on a few of the problems that each of you put on the table, because I think they would obtain vis-a-vis judges as well. One is the intractable problem of colorblindness, such a hegemonic way in which we think about solving problems of equality in this context. And I'm going to start by offering up this quote. If I were to say something like, the white race deems itself to be the dominant race in this country, so it is in prestige, in intelligence, and wealth. So it will continue to be for all time. Now, anyone want to co-sign that particular quote? Presumably not. But the reason I articulate that quote is because it appears in the context of the dissent in Plessy versus Ferguson. So remember, Justice Harlan's dissent in Plessy versus Ferguson is the moment in which colorblindness comes into being as a juridical idea. That coming into being is completely coextensive with the idea that the white race is going to be the dominant race. So for Justice Harlan, colorblindness and white dominance goes hand in hand. We need to lift that up, not in a good way, but to condemn it and reveal the extent to which colorblindness is there linked. Another way in which you should think about charging colorblindness, which I sometimes do with my students, is to say, look, there are two ways to think about race. One way is to say, you think race doesn't matter. I think it does. Well, flying papers. That's drama. So You think race doesn't matter. I think it does. To the extent that you pick your way, race doesn't matter. That's not neutral. That's a preference for a particular way of thinking about race. In other words, there are two competing conceptions of race. It matters, it doesn't. There's no neutral position here. And to the extent that we're having conversations that's predicated on the idea that colorblindness and race neutrality are one and the same thing, that is a problem. So I think we need to conceptually push back against that on the one hand, and on the other, link colorblindness to its jurisprudential origins in the idea that white supremacy is a part of the scene. Two other points, and then I'll stop. It seems to me that when we're thinking about Miranda warnings, and we ask ourselves, to what extent do we think we might need Miranda warnings? We don't say, well, we have Miranda warnings because we want to get to the hearts and minds of police officers and change their coercive biases. We say instead we're going to put in place a prophylactic, which doesn't really work as well as we might want, but put that to one side. We think about putting in place a prophylactic that we think will deal with coercion. Miranda warnings deals with coercion. With respect to biases, we should not focus so much on debiasing people. That may or may not happen. We should think about what mechanisms can we put in place that assumes that people are going to have biases. Just like we assume that police officers are going to be coercive, so we have Miranda warnings, we need to assume that people are going to be biased and ask tough questions. What does that mean? So it's not about changing your heart and mind necessarily. It's about putting in place mechanisms that assumes that your heart and mind is there to stay. The final thing I will say is this NIMBYism stuff, which is to say, not in my backyard or not in my racial body, I don't have biases. There is robust empirical evidence to suggest that progressive outfits in particular are ones in which biases are pervasive.
Can you say that again, please?
Particularly because, because people are not checking themselves before they wreck themselves. So that's really the problem.
Love the hip-hop.
So all of this says, I think all of this goes to judges as well. I don't have any particular insight about that, but I think the broad problems of the structural situations that judges find themselves in, whether in fact they're operating under colorblindness, whether they're engaged in introspection, are all mechanisms that I think produce a range of problems that we might otherwise want to contest.
Right, right. So that both shows us how judges have contributed to some of the framing we use around colorblindness in the first place, and then also how we need some of these more structural and institutional mechanisms to account for the biases that may be there, rather than going to each judge, one judge at a time, trying to change their outlook, their minds and hearts, like you said. So those can all work together when it comes to dealing with some of these judicial biases.
And a footnote on that, just think about how the pleadings rules work in civil litigation, right? So quite apart from whether a judge is, but you just can't bring a discrimination case or a class action case. There are some structural barriers, irrespective. So if we focus on is this judge biased and not on the ways in which process affects the ability to actually bring these substantive claims, you're kind of, screwed, so to speak.
And if you just watch tomorrow morning or wherever you are in a courtroom, how judges speak differently to African American kids, African American boys, African American girls, and their families in conjunction with any other race, frankly, you'll have the answer to that question. The data in the academics is great, but just watching it play out with this lens on, you will see sort of the danger of people in black robes thinking that they're above bias and what that does, just in sort of a developmental way of trying to get a kid's buy-in in terms of conditions of release or whatever. If you just watch that play out, you'll understand why we're failing.
So let's follow up on that, just on how this plays out more on a day-to-day, on the ground, you in the courtrooms, those of you who are in the courtroom. So what can defenders or other stakeholders, prosecutors, other stakeholders who may care about these racial injustices that we see, what can they do to help judges become aware, or help implement or insert some of these strategies or make those more likely? Are there any, even if it's difficult to change minds and hearts, are there any small steps that we can take as stakeholders to help this situation?
Well, since he did it again with the changing hearts, right? One of the things that I always said in my work at Vera, and we were looking at all of the major decision points that prosecutors have and using data, right? Because if you can't count it, you can't measure it. If you can't measure it, you can't manage it. And my philosophy wasn't about changing hearts. It was about managing conduct. And I think that that very same principle applies whether you are a defender or whether you're a judge. I've been in situations training judges on implicit bias where I would spend about 15 minutes talking about 2 different cases where I gave every single demographic except race. And we would have a 15 or 20-minute conversation. And at the end, I would simply ask the question, well, which defendant you thought got the better deal, the white one or the black one? And 80% of the time, different hands would go up. But when I said, well, I never gave you the race, right? Those were implicit assumptions that judges had made about what the race of the defendant was. Prosecutors, we do it. Defenders, we do it. And if you think about the arraignment process,
Yes.
where you've got hundreds of cases and a judge is trying to move it through, defenders, they've got to interview their clients, prosecutors, they've got hundreds of files. And it's at a time, it's the earliest point in the case when you're making some of the most important decisions, i.e. bail in someone's liberty, and you've got the least amount of information and the least amount of time. And that's when you refer back to all of those mental shortcuts and biases in making decisions. So if you want to start at one place where you're talking about the structure, think about what goes on in arraignments and what are some of the changes that you can make just at that point of the system.
It's such an important point, and I'm so glad that Wayne talked about the arraignment period of time, because other than just, am I going to go home today in a bail situation, you're thinking about numbers of charges and whether a misdemeanor will do where you've been brought a complaint that has 3 felonies on it by police. These are decisions that are being made, and I don't know what the data say, but I would be willing to bet that kids of color are charged more severely with more charges, and they're left that way until there's a plea bargain, where as opposed to kids who are not of color who come into the courthouse, we're making decisions up front about how to mitigate damage because we want to make sure that they get into college. And when that's the dichotomy, and it happens all the time. Roxbury sat a little crescent of our courthouse sat on Northeastern campus, so we had like a perfect Galapagos Islands to observe this stuff in. When those kids came in, the lengths that prosecutors and judges and defenders would go through, defenders were typically hired, the lengths that they would go to preserve a future for those kids was much, much different than what the lengths and the period of time that people would go through for the kids of color at the arraignment stage.
Right. And making assumptions about what their future will be without knowing the specifics about that child. Right. Okay, so we're already moving into interventions then. So let's just keep building on that some. Just where do we go from here, knowing that these various biases exist? So, Ms. Pruski, I know you've implemented, or I believe you may have implemented some strategies in your office among public defenders and figuring out how to reduce implicit bias with that group. Can you talk about what strategies you've used, whether it's been effective? Do you focus on the changing hearts and minds, or structures, or a combination of the 3?
Yeah, so I think we use a combination, changing hearts and minds and structural stuff. We've started things at the hiring level. So, for example, what we ask staff or potential staff of the public defender's office when we're interviewing people are questions that kind of get to where their head, well, I guess where their heart is when it comes to racial disparity. So, for example, we'll ask during attorney interviews, do you think there is a problem with racial disparity in the criminal justice system? And if so, how would you deal with that? I mean, sometimes people will answer the question, no, I don't think there's a problem. And clearly, those are not people we're going to hire, right? We also ask the question, and people it's interesting the response we get from this too, is we ask people the question, so you have a client of color who tells you that they wish to not have you as their attorney, but wish to have an attorney of color be their attorney. How do you respond? And if the response is, well, I would, spend time, I would, let them know that I'm really experienced and I'm a really good lawyer and I'm going to do a really good job for them. If that's the response, that kind of response gives us pause. If the response is, okay, talk to me about that. Like, where is that coming from? If the response is more about trying to get a better understanding about why that client might feel that way, and digging deeper and trying to get to the root of that. Now that's more in line with what we're looking for people that we hire. So it starts there. In terms of what we do once people are on staff is we've actually implemented a lot of training around racial justice because, well, Wisconsin is ranked, I don't know if it's still ranked #1 or #2 in the nation for racial, for DMC. It's like horrible. And Milwaukee has been found to be like the worst city in the country to be a young black man. So clearly Wisconsin has a lot of problems. So several years ago, our agency made a very deliberate, conscious decision to, we're going to do some really proactive stuff here to deal with this, not just in the system, but within our own agency as well. I mean, you got to clean your own house too, right? So one of the things that we started a few years ago that we implemented around the state, so we're a statewide agency, we've got 37 offices around the state, we've got about 600 staff, close to 400 of those are lawyers, and then we've got investigators and social worker type staff, and then our legal support staff. We implemented these racial bias discussion circles around the state, and we trained about 20 of our staff, again, like a cross-section of staff, so attorneys, non-attorneys, trained them to be facilitators for these circles, and we worked really closely with the YWCA in Madison, who does a lot of work. Part of their core mission is to end racial disparity. So we worked very closely with the YWCA in Madison to train our facilitators, did these racial bias discussion circles around the state, just with the main goal being to get people comfortable talking about race, right? And so, for example, in these discussion circles, one of the questions that was asked was, did you come to work for the Public Defender's Office because you have a desire to, end racism? And our facilitators were trained to not, if the answer that a staff person gave in the circle was, well, no, that really had nothing to do with it, that's like an okay answer. I mean, you just gotta we gotta be okay with, just getting people, comfortable talking about race and answering honestly and from the heart. So what we discovered when we did those racial bias discussion circles was that our staff wanted more. They wanted a lot more training. So we've done a few other programs since then, the most recent being a program focused on ourselves, okay? We've done some training about how to deal with it, when it's coming from, judges, prosecutors, police, and that kind of thing, and how to litigate racial disparity and implicit bias. But then, it's like, no, we need to look at ourselves too. And so we did this very intensive training for our staff last summer where we spent a half a day talking about our own implicit biases and asked our staff to take the implicit association test. And then we had a conversation at our trainings about, what did you think about that test and how did you feel about your results? And people were really willing and open to sharing how that looked. And we've incorporated, and I can talk about, at the training, we talk very specifically about things that we can do just with ourselves. So, take the IAT. Change your associations is another thing that we talk about with people. So, we have these automatic associations when we're reading that criminal complaint and we realize that our client is African American, are we automatically thinking guilty? Mm-hmm. And if we are, first we have to know that we're thinking that, right? So you have to be really conscious of what you're thinking, which can be hard. But once you become conscious of what you're thinking, and if you're thinking oh yes, this client is probably guilty, changing that association. So when you have a client who's African American, tell yourself, write it down on a piece of paper, this client is innocent. Things like that can help. we've really encouraged our staff to do some the data collection and accountability stuff. So we ask them, pull out your last 20 cases that you took to trial, and then look to see what the races of those clients were. Do you see a pattern there? The last 20 cases that you had an investigator work on, again, what were the races of those clients? And is there a pattern? What's going on there? Really taking a hard look and asking yourself whether, and it's going to be uncomfortable, right? Like, you might not like the answer, or you might be a little nervous about what it says about you, but you have to do that. And, and we all kind of start with like, well, we all became public defenders because we care about this stuff, and we're not immune to it because we're human and we have that fast brain thinking. So, so we have to look at that.
That's a great start. So I want to build, because you mentioned a lot of strategies there that you're already implementing, and I want to think about which of those may be transferable to some of the other stakeholders. Well, do we think they'll be effective with the prosecutors or judges or police, or are these things that are unique to public defenders because of the type of individual that would come and is attracted to a public defender type position? So you mentioned the dialogue and then wanting more dialogue and being willing to counter and confront their association. So a lot of that is the dealing with the hearts and minds that we may not think is as effective with the other stakeholders. There we may need more of the structural accountability, counting data. Do you think they would be equally as useful in the other groups, or would you get more resistance or pushback? I'm interested in hearing what the others think as well, panelists think as well.
For me, implicit bias training is this really interesting thing, because when you think about what training is, training is like, we don't know how to do something and we're learning how to do it, and then we're going to learn how to implement that. We all know how to be implicitly biased. We've been learning it our entire lives. So implicit bias training is not learning how not to plead. It's not learning about how not to be implicit bias. It's learning that it exists, and we need to be aware of it. So training is a little teeny tiny part of the battle for this. We need to really start thinking about, like, what does that mean? It's not an appendectomy. Like, I don't go to my implicit bias training and then go to work the next day and I'm like, oh, miracle. Training is maybe not the right thing that we need to be doing. Maybe implicit bias, quote unquote, training needs to be something that is addressed every single day before we go down to the courtroom. And for people who balk at that by saying, well, we don't have the time or the resource or anything like that, look at all the black and brown people that are in jail and prison, and think about all the time that they're spending because of our foolish time management. So I don't know that anybody is better off or less better off. I fundamentally believe that when prosecutors go to the job, they're not going in there being like, I cannot wait to lock up a bunch more black people than white people. I think that there's a core value that prosecutors and public defenders, especially coming out of law school, hold. We get in this really old traditional system that was invented hundreds of years ago by white people, and we just sort of stay in our lanes. But so I think that if we capture young people coming into the profession and make this part of the daily routine as opposed to once in a while hosted by a bar association, we can really chip away at the issue.
Right, so both making it more long-term versus just a one-off, and then also you also mentioned the two-step process of becoming aware and knowing that there are biases and you hold biases, and actually acting to counter those when you go do your job on a daily basis. Those are two different things. The biases in themselves aren't hurting anyone. It's when you act on the biases when it becomes more problematic.
I think the issue here, and I think both Gina and Adam are correct, I mean, the awareness is absolutely critical. It is important, but it only does so much. I mean, implicit biases are just that, they're implicit. And the structural issues we have in the structural biases are structural. And individual decision makers within the system can have the best of intentions and the most awareness they can possibly muster, and that's not going to change it. I think, honestly, we're at the point where, just like Professor Carbato talked about, color blindness is not a thing, right? And I think we need to acknowledge, we know that the biases exist, we know that the disparities exist, and we actually need to put structural checks and balances in where we are aware that these biases could come into play. So it's not at the individual level, but the actual system checking and rechecking, okay, this is a case where we know there is a history of potential for biases, so we have to stop and we have to see, and there are these extra steps we need to take in order to ensure that it's not occurring.
So let me sort of echo what Dr. Atkins said and put it in a real world context. Before I accepted the job at Vera, I flew to Milwaukee to meet with E. Michael McCann, who had been the district attorney there for over 30 years. And just as someone noted, at the time Wisconsin was number 1 in the incarceration rate of African American men. And Michael McCann admitted that Milwaukee was the engine that drove that train. And as well-intentioned as he was, so for example, he said, well, we know we have a problem, and if you can't help us figure it out, I'm going to take that as evidence of your incompetence. And I still took the job. But when he was addressing his prosecutors, he made a statement that he thought implicit bias, and then he said racism is like your mother's milk. You take it in at birth. And I sat there going, oh, hell, okay, this is how I'm going to start. Now, John Chisholm succeeded Michael McCann. And his approach was, look, we're going to accept that these biases exist. We're going to accept that there is a problem. One of the ways that we're going to deal with this is this data collection. And guess what? If we find a problem, together we're going to fix it. He didn't point fingers, and he created an environment that actually made it easy for his leadership to engage in this type of work. You know, I mean, we had access to every single file in all aspects of the office. It's similar to another prosecutor I worked with who said it's like voluntarily inviting the termites into your home. But the environment was created, and then it was all about changing structures.
Thank you. So I want to end right there. Let's thank all of our panelists. Those great insights. We have about 5 minutes left, so I wanted to be able to take some time to open it up to the audience. If you have any questions for the panelists, now is the time to come up and get your questions, specific questions answered. Please come to the mic.
Yes, ma'am. We can hear you, bro. We'll repeat the mic.
Gualt, I work with the OAG. I'm a juvenile prosecutor. We've been talking so far about these biases as if they're static. The person who comes into the position of prosecutor, they come into the position as a public defender. But I think given the disparities, these biases, these neural associations are still developing. So is there research about how exposure to these disparities are affecting the development of these biases over time?
I think in some ways your articulation answers the question, which is to say there are a number of different socialization mechanisms through which these biases get instantiated. So it's not easy to then pinpoint a particular moment. What the priming studies do, though, is to suggest that, look, if we actually, in this particular instance, prime you to think in this particular way, then we can see that association. So we can think what it might mean then to be exposed in a work environment in which the very representation of African Americans in the criminal justice system instantiated the thing you're supposed to be checking. So one has every reason to believe that the context of the work shapes the biases as well. And indeed, there's a particular study, I'm not going to remember the particularities of it again, with Jennifer Herberhart, which suggests that when people are exposed to the overrepresentation of African Americans in the criminal justice system and told about that empirically, that actually shores up their hard on punishment approach. So it's very simpatico with what you've just suggested.
And if I can just hold up the young brother right here for being here as a prosecutor of color, I appreciate. All right, fam, I appreciate you. Never happens. It never happens. So I'm really happy to see you all here. So what I would encourage you to think about, especially as a prosecutor, because you have the opportunity to talk to lots of stakeholders, and a major stakeholder that you talk to is your school department. Think about how you learned about black people in school. Think about how you learned about black history in school. You watched Roots to cover slavery, didn't mention like sugar cane, didn't mention how economies were built. Then you did the civil rights movement, which was Rosa, Martin, Obama, done. And that's how we learn about black people. And the reason I bring that up is because at every moment, at every opportunity that we have to undo these things, in adolescent brain development and early child development, and as adults, young adults, we come to the prosecutor's office with our brains still developing. And it provides an incredible opportunity in law school, college law school, and just after we start, to undo a lot of these things just by what you're talking about. So I appreciate you bringing up the question because, like my man said, you answered it.
Thanks. Now it's time for one more question.
Thank you guys for being here. Thanks, Adam. I'm currently reading Locking Up Our Home by James Norman Jr.
Yeah.
It's a really powerful book that
Yep.
talks about the black community, specifically DC's contribution to mass incarceration. And James talked about having black prosecutors who weren't willing to give black defendants the same opportunity to get their sentence. He talked about poverty and how that puts so much pressure on the black community and the level of crime rate we've experienced, which caused folks like us who were supposed to be out on the field fighting biases and fixing the system and doing all the great work to be a part of that same system, which we're trying to fix today. So as black prosecutors and folks who've been involved in this work, can you touch a little bit on our own biases and the things we've done to contribute to mass incarceration and the issues we have now?
Absolutely. I'll start. We are no better. Jim, James, Wayne, me, we see everything the same way that other people see, implicitly. That is not to say that we are subject to the same pitfalls when it comes to seeing youth of color in a certain way. I grew up a product of the child welfare system, juvenile justice system. And as a result, just of that life experience, as a result, when I see a young person, I might see them differently than my coworker. That does not mean that I see 4 black kids on the corner in my neighborhood differently than my white roommate. We suffer the same thing as progressive white liberals. It's like, nah, it can't be us. So we have to double down on that idea that we aren't the house slave. You know what I'm saying? We need to understand that our privilege in being where we're at requires us to view this through a bigger lens and to do what we can to do in that position to thwart that. It's not something that we do very well all the time for a lot of behavioral reasons, but it doesn't make it less important.
Yeah. So I actually agree with Adam, and I think a lot of times it's not only just about race, but it's also about culture. You know, and so example, being a young black man growing up in Brooklyn, when I was in the district attorney's office, it took me until a 3rd time I heard the same story. Well, we recovered the handgun because the butt of the gun was sticking out from between the consoles. And after hearing the same exact story 3 times, I'm like, well, wait a minute. I drive around Brooklyn with a lot of friends, and not all of them are upstanding citizens. And that's not my experience, right? So that actually led me to start asking more probing questions and getting answers that just didn't add up. The other thing I would say, especially when you're early in your career, you can get co-opted by the system.
Yes.
And Zach Carter, who is a former U.S. attorney in the Eastern District of New York, once spoke to a group of us as young prosecutors. And he basically said, if you do this work for any length of time, there's going to be more than one time in your career where you're going to be faced with certain ethical decisions or decisions that may go against the grain of the culture of your office. And if you make the wrong decision because you're afraid to lose your job when individuals lost their lives to give us the opportunity to do what we do,
Yes.
then we don't need you there. And the third thing is, if you stay the course and you actually move up in rank and you become a boss in the office, right? There was a time in my career where I was dealing with one case at a time, but then when I'm managing 20 or 30 assistants, multiply that by 70, 80 cases, it means all of a sudden I have an opportunity not to just impact those cases, but to impact those prosecutors that I supervise.
Yes.
Great. Thanks again to our panel.
Thank you. Very nice to meet you. Cheers.
Excellent.
All right, thank you, everyone. Thank you again to Professor Corbado for getting us started, and to Professor Williams for moderating this great panel. Thank you for all of your insights. We're going to take literally a 7-minute break, and you will want to be back to hear from Emily Baxter, who is the Executive Director of We Are All Children Here. She runs a phenomenal media advocacy organization. Also, as you're going out to stretch, please follow us on Twitter at GeorgetownJJC and use the hashtag for the conference, Right to Remain Children. And the 2 is the numerical 2. All right, so stretch, and we'll see you back. Hear from Emily Baxter. Thank you.
Hello. Can you hear me? Okay. Several years ago, a man came into the small legal nonprofit where I worked, looking for help with an expungement. You see, his criminal record had been plaguing him. Several years ago, when this man was in high school, he had swiped a single bottle of Mick Golden Light from a gas station refrigerator in a failed and foolish attempt to impress a girl at a house party. Dude didn't make it to the end of the lot before he was nabbed. He was charged with a misdemeanor theft, pled down to a petty, cut a check, and thought he was done with it. But it didn't go away. In fact, more than a decade later, this man decided he would like to become a cop, only to find that his petty theft is a permanent prohibitor from ever becoming a peace officer. More recently, I heard another story by another man. When he was 17 years old, he and 7 of his closest guy friends, so 8 teenage boys, decided that they would break into a local liquor distribution plant. They hatched out this plan over the course of several months. They had walkie-talkies in a decoy van. They had a mock-up of the blueprint of the inside of the building so they would know where to go for the returnables. You can stack them and run, and schnapps for the girls. After several months of planning, they pulled it off. They took a hacksaw to the side of the building, got away with a load of liquor, took it out to a cabin left vacant during winter months, and stashed the loot until the hubbub could die down. Once it did, he said, they threw an epic senior party. But that wasn't the most interesting part, he said. The most interesting thing was that these were transferable skills. The attention to detail, the plotting, the delayed gratification, even an interest in criminology. Perhaps it's no surprise, he said, that 2 of us are now chiefs of police. One's a college professor, one's a nurse, one's a victim's advocate, but importantly, 2 are now chiefs of police. You see, while there are many similarities between these 2 stories, perhaps the teenage propensity for stealing beer to impress girls being among the, quite high among them, there are also several important differences. For example, the 8 burglars were all white and solidly situated within the middle class, whereas our single teen was a poor person of color. There's another important distinction. The single teen was caught and will likely pay for that theft for the rest of his life, while the 8 burglars were not, and will only be reminded of their criminal acts over friendly beers at a ball game. Over the last few years, I've been working on a project that examines the stories of people like the 8 burglars, those who got away with it, within the context of our country's mass incarceration, mass criminalization, mass disaster. You see, while 1 in 4 people in the United States has a criminal record, I contend that 4 in 4 have a criminal history. For the past few years, I've been asking people like me, the 75% of people in the United States with a criminal history but no record, what have you had the luxury to forget? Today, I want to share with you some of these stories, focusing this morning on crimes committed while brains are still developing. Some are petty, some are serious. Some happened decades ago, others a bit more recently. In doing so, I hope to offer a personal way of examining the true effects of our legal system upon people and the disparate impact of those systems upon poor people, people of color, and indigenous people across the United States. Because mass criminalization is not a crisis born equally across our country. For example, the Sentencing Project, the lifetime likelihood of imprisonment for black males born in 2001 is 1 in 3. For white women, it's 1 in 111. Now, this is not to say that white women aren't committing crimes, right? But we're not who you see, proportionately speaking, within our criminal justice system. Importantly, note that rates of offending do not come close to explaining these disparities. Looking at just our war on drugs, arguably one of the greatest contributing factors to our current carceral crisis, black and white individuals use and sell drugs at roughly the same rates. Yet black individuals are far more likely to be stopped, searched, arrested, prosecuted, convicted, and punished than are whites for engaging in the same behavior. And as you know, these disparities start early. For example, black youth as young as 5 are suspended and their actions criminalized at far higher rates than their white classmates, again, for engaging in the same behavior. And note that kids these days are growing up in the data age. That means the scarlet letter that's stamped upon the ether cannot be scrubbed clean. Now, criminal and juvenile records are no minor matter. They influence nearly every aspect of life, from employment to housing to professional licensure and access to public benefits, education, immigration, the ability to travel, and the right to cast a ballot. And these are just a few of the myriad consequences that attach to a record. This is death by 1,000 cuts, or where a pound of flesh is no longer enough. It's as if we believe that the only appropriate consequences are those that eviscerate a person, his or her family, and his or her future too. So criminal histories affect nearly every aspect of who we are and how we engage with the world, from personal to professional, from social to psychological. We are confined and defined by our criminal acts. But not for everyone. In fact, just for a few of us. Just for 1 in 4 of us. What about the other 75%? Over the last few years, I've collected more than 300 stories of people who have gotten away with it. Again, this morning we're going to focus on the stories of people who committed and got away with crimes in their youth. As I said, the stories range in severity from quite serious, like this student and his aggravated robbery. I just wish I'd made a different decision, he said. To the relatively innocuous, like this woman who as a young teen shoplifted bangles and LPs to cope with the loss of her mother. She is now a recognized leader in her community. The responses to the recollections of past transgressions are also varied. Like this woman who told me about a time as a teen when she would break into her neighbors' homes to eat their ice cream, rifle through their junk drawers, and occasionally swipe some silver. She laughed, surmising, "Let's just say I'm never going to be president." This was not in a recent interview. She is now a CFO. Some people mention not just the luxury to forget, but the luxury to not regret, while others are deeply sorry. Like this woman who could have been charged with harassment, bullying, terroristic threats, trespassing, and criminal damage to property. She is now a probation officer. And there are some that just cannot begin to imagine what life would be like now had they been caught then, like the woman for whom I took this photograph. When she was 16 years old, she said she was a bit of a nerd, a chemistry buff. One bored July day, she and some of her nerd friends decided that they would make their own homemade napalm, which apparently you can do with just a few common household ingredients. They whipped up this highly flammable viscous gel in an apple cider glass jar and let it sit overnight. The next morning, they took it out to a state park to find the small, enclosed, ideal space upon which they could test their substance. They doused the inside of the porta potty with this gel, lit a tennis ball on fire, lobbed it in, and watched it blow. They then ran back to their cars and drove the speed limit the entire way home, terrified over what had just happened. The day that I interviewed her, that morning, she had been keeping a 3-month-old heart alive with her index finger, beating it for the baby. She's a pediatrician. In many states, an arson or the destruction of a structure with a homemade explosive would be a permanent bar from working with vulnerable individuals, most definitely children. It wouldn't have mattered that she was just a kid when it happened. It wouldn't have mattered that no one got hurt. It wouldn't have mattered that she was terribly sorry for what she had done. All that would matter was that the act occurred and she was caught and she would be done. It gives you pause, doesn't it? Or at least I think it should. When you consider all of the waste in the states when we're foreclosing futures before brains are even fully developed. Time and again, I heard from people who recognize that crime is an event in a life course, not a static characteristic of one's being. Like this teacher who said, experimenting with delinquency is normal and so is giving it up. I have that story, he said. Everybody has that story. If you find someone who claims that they've never committed a crime, either they're lying, they have a poor memory, or they're very abnormal. And I've heard some truly heartbreaking stories, like from the gentleman for whom I took this photograph. At 15, he struggled to survive. He soon found that joining a gang offered him a chance at getting to school and back without getting beaten up. But that didn't come for free. One Saturday morning, he was told that if he didn't pick up a lead pipe and hit a child that looked a lot like him, a member of a rival gang, that he would be the one beaten. He said he made the choice that day that he has regretted every day since. In fact, not a month can go by where he doesn't wake up at least once in the middle of the night screaming, thinking that it's all happening again. He picked up that pipe and he hit that child. The boy was dragged away. Had he been caught, he would have been charged with first-degree assault for the benefit of a gang, at the very least. He would have been certified to stand trial as an adult. He likely would have been convicted. Once convicted, he would have entered that system, that vicious cycle of going in prison, out of prison, in prison, out of prison, in prison, out of prison. He wasn't charged. He graduated from high school. He got a scholarship to go to college, where for the first time he said he could read an entire paragraph. He could complete a math problem, because for the first time he wasn't constantly checking over his shoulder to see what was coming next. He was safe. He could concentrate. His grades skyrocketed. He went on to graduate school and now has a PhD in biophysics. His future was not foreclosed. We Are All Criminals is about the human cost of mass criminalization. We have all violated the law. But far more importantly, we're all human. And some of us, perhaps 1 in 4 of us, may be in need of a second chance. But make no mistake, this project is also a commentary on the disparate impact of our nation's policies, policing, and prosecution. Many, not all, but many of the participants have benefited from belonging to a race and class that is not overrepresented in our criminal justice system. And some of the participants have been pretty straight up about that. As a teenager, he fashioned himself to be the next Steven Spielberg. One day, he and his friends decided to direct and star in a mock-up of Dirty Harry. They dressed up as bank robbers, complete with replica firearms, briefcases stuffed with fake cash, and nylons pulled down over their heads. The camera was set up on the back of a car, the venue was an alley, and the backdrop was a bank. An open for business, middle of the day, bustling with bodies bank. Within minutes, they were surrounded by squads. Drop your weapons. One of the guys refused to put his fake gun down, not fully comprehending what was happening. The police officers continued to shout at him until he understood and complied. Afterwards, this man said, they lectured us energetically till they ran out of words. They even then let us finish the shoot. Or take the gentleman for whom I took this fairly unappetizing photograph. Now a successful business owner, years ago, he and a friend tried to terrorize a buddy and a pizza delivery guy with a fake gun. When the police caught up with him, he said, my baby white face, Letterman jacket, and compliant response to police de-escalated the situation quickly. At a certain point, I could tell one cop was almost laughing at the comical scene. Now, if we had been two African-American teens, we would have been at least booked, probably jailed, and maybe even shot. Instead, we got back in the car and drove home. I grew up in a very affluent town, he said. It was the kind of place where it was easy not to have contact with police. The few interactions I had were very respectful and innocuous. A tap on the shoulder, a suggestion to go home. Not everybody is afforded that same presumption of innocence. For some, in particular, black men and youth in America, their mere existence is seen as always already criminal. So while you're thinking about the stories of the people who got away with it, consider the lives, the narratives of those in the court system or serving time or suffering under the weight of a juvenile or criminal record right now, many for engaging in the same behavior. Consider those too who were followed, accused, arrested, abused, chewed up, and spat out as if they weren't somebody's son, somebody's daughter. Sister, brother, mentor, leader, believer. Like the black teens just trying to enjoy the sun at a Texas pool party, or the black student sitting at her desk in South Carolina, or the 5 black teens and preteens just trying to make it home after a basketball game in a Michigan park. Treated as always already criminal. If the criminal justice system was designed by people who believe that they might one day be involved, he said, or I would add, those who have been involved, then we would have justice. So I ask you, what's your story? What would your chalkboard say? What would life be like for you if you had to check yes? We Are All Criminals seeks to close the empathy chasm that dominates and degrades our society, the pitfall of us versus them. This is a call for reason, equity, justice, and mercy, and acknowledged ownership in the problem as well as the solution, so that soon we may all be defined by our true worth, not our worst moments, and importantly, so that our youth have the right to remain children. Thank you.
Wow. Thank you, Emily. Thank you for reminding us that indeed we are all criminals, notwithstanding the racial makeup of most courts and prisons and detention facilities across the country. So let me call up everyone on the next panel. If you will just come up and take your seats, that would be great. Justice Hines and Christy Lopez and Paul Butler. So I want to talk to you about the reasonable black child. Back in 2015, I represented a young man who I will call Andre. He was a 15-year-old black male who was walking down the street here in Washington, D.C. There was no report of crime, and even according to the police reports, he was with a friend, and neither of the boys were engaged in any type of suspicious activity. Yet, the police officers pulled up next to them, asked them if they had heard any gunshots, and the boys said no. When the boys kept walking, the police asked them, "Hey, lift up your shirts and let me see your waistband." And both boys complied. Still unsatisfied, the officers asked the boys for permission to search them completely, at which point either Andre, my client, or his friend said yes. 4 uniformed officers exited their police car, forced the boys against the wall, and began to frisk them. Now, under the most common reading of the Fourth Amendment, which is designed to protect all of us against unreasonable searches and seizures, I venture to guess that most courts would conclude that the officer's conduct was completely lawful, that the officer's initial contact and search of the boys was a consensual encounter. But is this a fair interpretation of the encounter between Andre and the police officers? Why did the officers approach them in the first place? And should the officers have even asked the boys for permission? And would a reasonable black youth like Andre have really felt free to decline the officer's request and to walk away? Now, this is just one case from Washington, D.C., but I have heard stories like this all across the country. And we need only look at the internet. Consider 14-year-old black male consider Emilio Mayfield, who was 16 years old in September of 2015, when an officer in Stockton, California, stopped him at 8:30 in the morning for jaywalking in a bus lane on his way to school. The officers told Emilio to sit down, and when Emilio refused, 9 officers became involved, at least 4 of whom piled on top of him after slamming him to the ground. And consider 14-year-old black male Tremaine McMillan, who was at the beach with his family, friends, and a puppy on Memorial Day in May of 2013, when a Miami-Dade police officer forced him to the ground and held him in a chokehold. Why? Because the officer saw Tremaine roughhousing with a friend at the beach and told him to stop. As Tremaine walked away with his puppy in his arms, the officers followed him, jumped out of his vehicle, and put him in the chokehold. When the officers were asked, well, why was all of that necessary in this circumstance, the officer said, and I quote, "Well, he had clenched fists, and he gave me dehumanizing stares." For those of you who think that maybe Emilio and Tremaine might have avoided the police if they had behaved like good little boys, or if they had been more respectful of the police, let's consider the 3 black males aged 9 and 10 who were stopped for riding their bicycles at night. And the officer's stated justification in that case was, well, we have a problem with juveniles, and these are juveniles. And what about the teenage girl who was arrested in another city for eating a lollipop on the metro? And when the civilians asked the officer why they were stopping her for eating on a train, the officer turned back and yelled, "Well, it's illegal to eat on a metro." Black children, especially black boys, are policed like no one else in society. They are stopped for being out of place in a white neighborhood, for matching some vague description of an alleged suspect, for being out too late, for talking back, for laughing loudly, for looking at police the wrong way, for sitting on their own porch, hanging out on the corner, and breathing too hard. It is my greatest fear that the Fourth Amendment has lost its power for young African American youth. So my question to all of us is, what are we going to do about it? How can we ensure that Black youth and all children of color get the same Fourth Amendment protections as white youth? There are at least 3 great shortcomings to the existing Fourth Amendment framework. Wren versus United States, which permits a racially pretext stop by the police. The reasonable person standard, which undergirds all of the Fourth Amendment, but yet ignores race and adolescence, and reasonable articulable suspicion and probable cause, factors that are merely a proxy for race. So let me jump to the reasonable person standard. Until very recently, juveniles were evaluated by the same standard of conduct as adults in the criminal context. The reasonable person has been defined as a person who possesses the intelligence, educational background, and level of prudence and temperament of an average adult. Until recently, there was no account of race and adolescence, but now there might be hope. There is hope in the recent Supreme Court case, JDB versus North Carolina, which finally pierced the veil of the reasonable person standard, at least as it relates to children. In that case, Justice Sotomayor held that a child's age must be factored into the determination of whether a child was in custody for purposes of Miranda. Now, Sotomayor's opinion does 2 things that are essential for our conversation about Fourth Amendment protections for children of color. First, it explicitly adopted the reasonable child standard in the juvenile and criminal justice context. Specifically, the court recognized that a reasonable child, subject to police questioning, will sometimes feel pressured to submit when a reasonable person would feel free to go. And because the differences between children and adults are self-evident to any one of us who is a child himself, we think it clear, the court thought it clear that the courts could account for that reality without doing violence to the objective nature of the custody analysis. Now, since JDB, a number of scholars and courts have called for the extension of the reasonable child standard into other aspects of the juvenile and criminal law, including the Fourth Amendment. So JDB does give me hope, but I am afraid that it may not go far enough for Black children. So maybe we need a reasonable Black child standard? But honestly, my proposition is not as radical as it sounds. What I really mean to ask is simply this: what would it look like if we meaningfully acknowledged how race and adolescence affect every aspect of the Fourth Amendment analysis? The seizure inquiry, the consent to search doctrine, the evaluation of reasonable articulable suspicion, just to name a few. Now, let's think back to Andre's story that I started with. Did Andre and his friend truly consent to talk to the police, or is it more accurate to say that they were seized by those officers? The question is whether or not the officers' words and behavior would have communicated to a reasonable child like Andre that he no longer has the liberty to walk away. Would Andre's race and his age have had any bearing on whether or not he felt free to leave? And of course, the answer is yes. We already know that there is a real power imbalance between children and adults, but there's also a growing body of research on adolescent development that confirms that youth are socialized to comply with adults. They are less experienced and less knowledgeable about their legal rights. They have less cognitive capacity to think ahead and weigh the advantages and disadvantages of consent. And specifically in the law enforcement context, research shows that adolescents are more likely than adults to make decisions that are compliant with adult authority figures. And how would race affect Andre's interaction with the police. Although there isn't the same body of empirical research on how Black Americans interact with law enforcement, there is a wealth of documented, anecdotal, and qualitative research on how Black youth in particular perceive and respond to the police. Perceptions of law enforcement are shaped by the vicarious and collective experiences of the entire Black community. Black parents have long trained their children to what? Always keep your hands up. Avoid sudden movements. Be respectful and courteous whenever you see an officer. Now, all of these experiences lead a reasonable Black child to be more afraid of the police and do one of two things: either to comply with whatever the officer says or to run like hell to get out of the way. Now, then there is the other question, the question of reasonable justification for a police stop. Yes, police officers may stop and frisk a child like Andre without his consent, as long as they either have reasonable articulable suspicion to believe that Andre was engaged in some criminal conduct or that he was armed and dangerous. And we all know the factors that may be used to justify a stop or a frisk: high crime neighborhood, association with known suspects, flight, furtive gestures, description matches, nervousness, departure upon seeing the police, and temporal and spatial proximity to a crime. But what is the problem with these factors? Most obviously, many of them are proxies for race, right? Obviously, the high crime area, association with known suspects when you live in a community where Black men are stopped over and over and over again, temporal and spatial proximity to the crimes that police stop in your very neighborhood, and description matches that invariably include Black race. But there is another problem with these factors. It is that the factors simply fail to acknowledge the ways in which assumptions and biases about adolescents and about children of color in particular lead many of us to observe and interpret normal adolescent behavior as suspicious. Now, Devin Carbado got us very far along the way. Several studies have found that individuals are more likely to interpret ambiguous behaviors by Blacks as more aggressive and consistent with violent intentions, while interpreting those same behaviors among whites as innocent and harmless. So in one study, which we have already heard about, research has shown that participants with higher levels of implicit racial bias took longer to perceive Black faces morph from unambiguous hostility to unambiguous friendliness, but not white faces. The studies show that participants also perceived the onset of hostility much earlier among Black faces than among white faces. In another study that Professor Carbado talked about, researchers found that individuals were more likely to believe that an ambiguous object was a weapon or a crime-related object when it was associated with a white face than with a Black face rather than with a white face. And in the most important study for today's discussion is another one that Professor Carbado brought to our attention. It is a study in which researchers used a number of strategies, and one of their study methodologies was to show police officers and the general public a series of photographs of Black, white, and Latino children who were engaged in some sort of purported felony or misdemeanor activity. And those officers and general public were asked to estimate the age and the alleged culpability or purported culpability of those youth. And just as Professor Carbado told us, among the general public, the participants perceived African American felony youth suspects to be 4.53 years older than they actually were. Among the law enforcement population, the participants rated African American felony youth suspects as 4.59 years older than they actually were. To put an emphasis on this point, that means a 16-year-old boy like Emilio or the 15-year-old Andre was actually perceived to be 19 years old or 20 years old long before he was. So what do all these studies mean for us collectively in our discussion today? They mean that juvenile justice stakeholders are more likely to interpret normal adolescent behavior among children of color as adult-like, as suspicious, as criminal. And that is where I really want to end, and that is with the assignment of meaning to specific adolescent behaviors, behaviors like flight, like nervousness, like furtive gestures. The second important thing that JDB versus North Carolina did for us was it resurrected some very important language from the Supreme Court's seminal case regarding the meaning of flight from police. In JDB, the court noted that age generates common sense conclusions about behaviors and perceptions of suspects. Well, in 2009, in Illinois versus Wardlow, the court held that the determination of reasonable suspicion must be based on common sense judgments and inferences about human behavior. So what does this legal language mean? It means that if my client, Andre, had run from the police, then the police could lawfully infer, based on common sense, that Andre had a guilty conscience. But is this a fair inference for Andre and for other youth of color? Justice Stevens clearly had concerns about this inference when he wrote in the concurrence to Illinois versus Wardlow that among some citizens, particularly minorities, there is also the possibility that fleeing is entirely innocent. The person could believe that contact with the police is itself a dangerous proposition. For such a person, unprovoked flight is neither aberrant nor abnormal. Moreover, these concerns and fears are known to the police officers themselves. Now, fortunately, several federal and state courts are beginning to acknowledge that innocent people, innocent Black people, run for wholly legitimate reasons. But that requires us as a community of stakeholders in the juvenile justice system to acknowledge and recognize the importance of race in the Fourth Amendment analysis, which takes us to our panel discussion with Justice Geraldine Hines, who sits on the Supreme Court of Massachusetts and who had the courage to explicitly consider race in her Fourth Amendment analysis of the meaning of flight. And so we will hear from Justice Hines and other great panelists like Paul Butler, Christy Lopez, Justin Hansford, and Lisa Thoreau, who will help us think about race, adolescence, and the Fourth Amendment. And as I transition to the panel, I look over here and I see all my Georgetown colleagues, and this looks like an academic discussion among, Georgetown faculty. But I encourage you to read their bios, because this is a powerful group of activists who have been out on the ground in Ferguson, in Boston, and all across the country advocating for reform in policing and have been thinking about the Fourth Amendment. So I want to engage them in a conversation. All right. So let me start with you, Justice Hines. And I'm pulling up Commonwealth versus Warren. Now, the state of Massachusetts, or the Supreme Court of Massachusetts, has been attentive to the role of race in the Fourth Amendment. And so you have been a trailblazer, and a number of us, and I know in our juvenile justice community, have taken heed. But you authored an opinion, Commonwealth versus Warren, in which you acknowledge that the race of the defendant can, in fact, be relevant to the Fourth Amendment analysis. So, but for people in the audience who don't know about Commonwealth versus Warren, can you tell us briefly what that case is about and how you all arrived at your decision?
Well, everybody here knows the scenario. When you have young Black men and police officers having encounters with young Black men, you're going to have a story like the story that led to this case. There was a breaking and entering at 10 o'clock at night. Suspects very vaguely described 3 black guys, 2 wearing hoodies, 1 with a red hoodie. 10 minutes later, the police see 2 black guys, not a guy with a red hoodie. And so the police officer asks if he can talk to them. And they say, no, you can't talk to us. So the police officer doesn't give up. He reports the description of these 2 young men and arrange for them to be met on the other side of a park by 2 other police officers. They're met there, and the kid with the gun decides to run. But it just so happened that he had been ordered to stop before he did that. So the practitioners in the room will understand that that's the crucial point where he's been seized, when the police officer demands that he stops. He doesn't know anything about this child, except that there was a B&E that occurred half an hour earlier, and they're a mile away from the scene. So the issue in the case was whether or not the police had reasonable suspicion to order the stop. And I wish the decision that we made was as important as people think it is. But really all we said was that the police did not have reasonable suspicion for the stop based on the very vague description that they had of the perpetrators. But what we did do, because the evidence was in the appellate record, everybody in Boston knows about the police relationship with young black men. The police department issued its own study that showed that black men in Boston were more likely to be stopped by the police, and a higher percentage were more likely to be stopped more than once by the police. So we had that evidence in the record. The defense attorney did not, as far as I know, attempt to bring this research into the case. The appeals court cited the research in the case, and so we looked at it and we decided that this was very important in helping judges decide this reasonable suspicion factor, which is just loaded with racial code words and racial inquiries, like high crime area, the person, flight, the wearing apparel, whether the person looks at the police officer or the person declines to look at the police officer. It's whatever you do, it's going to be a factor. So we said on the basis of this evidence that in the case of a black man who ran from the police, exercised his right, mind you, because our jurisprudence says that you're not obligated to talk to a police officer unless there's a legitimate seizure of your person. So as far as we were concerned, they had the right to run. And what we said was that we don't say that you can never use flight as a part of the reasonable suspicion analysis, but we did say that if the defendant is black and the event happened in Boston, that the judges should take account of what this history is, what these studies have shown about the interaction between black men and the police in deciding whether or not flight contributed to the reasonable suspicion analysis. Because I guess the phrase that's been out and about is, we said that he could just as easily be running to escape the indignity of another racial profiling than to be engaged in some sort of guilty behavior. So I think that a lot of people misunderstood the case because I'm not a Facebook fan, but I understand that the case was trending on Facebook. And all of the uninformed and commentators accused us of giving black men a free check to run whenever they had an encounter with the police, but that was not what we said. And quite frankly, we were worried about the implications of that. A black man running from a police officer who's attempting what otherwise appears to be a legitimate inquiry. We know how that comes out sometimes. So that was a concern, but that's what the law says, that you don't have to talk to the police officer if you don't want to. It's your right to leave. It's your right not to talk. The Supreme Court said as much in the Bostic case. When the police got on the bus and wanted to examine him as a drug dealer, the test was whether or not Mr. Bostic felt free to terminate the encounter, which made it easier for the court to accept the outcome that it ultimately decided on, because he definitely wasn't free to get off the bus in the middle of nowhere and exercise his Fourth Amendment rights. So that's kind of the backdrop of the case, that it's been cited at least one other time. It's in a law review article, so get going,
And it will
folks.
be in more. Just wait. And let me jump in and just say a couple of things. Notwithstanding your accusers, let me speak for the advocates for racial justice and advocates for children in the room when I say that we've read the case closely and it is as important as folks, yes. It is as important as folks say that it is, but for different reasons. The importance of this case lies in exactly what you said, which is this notion of the loaded racial, the case being, or the advocacy and the arguments being loaded with racially coded words. And the importance of the case is your willingness to call it out and refusing to divorce the history of race relations from the Fourth Amendment analysis, which I think is absolutely critical. Another thing that I want to draw out, and maybe just for a second draw in other people, is this takeaway. You alluded to the fact that you have no knowledge that the defense attorneys, at least at the trial level, had raised this data, the racial disparity data. And so I really, as we think about takeaways, want to think about how advocates can be bringing that to not only the appellate court's decision, but to the trial court's attention. So if anybody wants to add anything to that, I think about, Paul as a former prosecutor. So it's not just the role of the defense attorney, right? It's the role of all of us to get that data out. So I guess the first question I would ask, as a judge, putting yourself for a moment on the trial level, would that data have mattered to you, maybe at the trial level?
Oh, yeah, absolutely. I mean, it depends on the judge, but I think that it's the Boston Police Department's own study.
Yeah.
It wasn't some liberal group that's out there trying to manufacture some numbers. It was Boston's own study. And Boston was beside itself when the case came out and they realized that their own numbers were being used to justify this result. But I think that we don't see enough of the creativity that I think somebody mentioned earlier today. I think people get beaten down by what they know is the lived experience, as you said, of the black and brown kids who come into court, and they get beaten down by what they think is going to happen in the courts. And they're out there trying to get the best outcome in the quickest time possible. Something like this would have taken a lot of time to develop. And a lot of times, public defenders, you don't have time to do that kind of work. But if you've got something like this that can be used, and it's going to have an effect, a carryover effect, I think it's really important to let the judges know.
Yeah.
And they can decide whether they want to make that part of the reasonable suspicion calculus, but it's out there.
All right, and we'll come back in a little bit and talk to Christy Lopez about data collection and how you go about it if you're a defense attorney or some other advocate who doesn't have that data. But Paul, I wanted to ask you if you have any thoughts about how to advocate these questions before the trial court level, if you want to weigh in.
So Professor Hennings has proposed that race be part of Fourth Amendment analysis. So when courts think about whether the police constitutionally stop someone, for example, are courts allowed to factor in race? And that's actually something that the law is good at. So we've been thinking today a lot about things that the law is bad at. The law is actually kind of good at those kinds of law line drawing issues. So who is the reasonable person? Is she a woman? Are they trans? Is he black? So in the law, this comes up most often in the context of provocation, the difference between murder and manslaughter in lots of jurisdictions. And England has developed an important line of cases that talk about who this reasonable person is. And so in the law of provocation, you get manslaughter versus murder. You get less punishment, significantly less punishment for manslaughter. You get that if a reasonable person would have been provoked. And so then judges have to figure out, and jurors have to figure out, who is the reasonable person? And so it comes up in the context of someone says that she was provoked because someone called her the N word, or someone called her the B word, or someone called a gay person the F word. So does the jury get to think about the fact that this person is African American, that he's gay, that she's a woman? And for a long time, the law in England was no. It's just this generic reasonable person. And that led to a series of outcomes in cases that were extremely unfair. So the jury doesn't get to consider the fact that the guy is black. A reasonable black person would respond differently to being called the N-word than a reasonable white person, right? The reasonable black person would be more provoked. If the jury doesn't get to hear that, then the person's guilty of murder. In England, it was literally a life or a death situation because the mandatory punishment for murder was capital punishment was death, whereas life was what you got for manslaughter. And so the courts there evolved to say that the reasonable person, when you do that analysis, you get to be real. Judges should keep it real, and they should think about, in a specific set of circumstances, whether that characteristic, whether race, gender, sexual orientation, religion, whether that would matter to how the provocation is received. And so in the Fourth Amendment context, again, just as judges do that with substantive criminal law, they also should be able to do it with regard to procedural law. So I think Professor Henning's proposal is extremely important. All of the information that we've received, the important information we've received at this conference today has suggested that race matters, right? And everybody in the courtroom's thinking about it. We've heard prosecutors are thinking about it, jurors are thinking about it, the police are thinking about it, even defense attorneys are thinking about it. If race is doing all this work, should judges be the only people in the courtroom who ignore it? And the answer is no. And not just no for fairness in an individual case, but because, as Professor Carbado warned us earlier, the whole doctrine of colorblindness, the whole idea of not thinking about race, is all about white supremacy. So it's not racially neutral. If we don't think about color, then we're entrenching white privilege.
Yeah. So, Professor Butler, so Justice Hines has introduced some of the pushback that she has gotten, right? Some of her accusers. And I want to press this out. I mean, I would love for sort of my radical proposal to actually be adopted by the courts. But I imagine that there will be a lot of pushback. And so let me speak for the police officers who might be in the room or listening in. I can imagine that many would say that considering individualized factors like race and adolescence creates a slippery slope that would be very difficult for police officers to implement. And it becomes unreasonable to suspect or to expect that police officers would modify their behavior or change the nature of their interactions with young youth, young black youth versus young Asian youth versus young white youth, depending upon their background. And so is it really impossible for us to conceive of a way in which officers might factor in race and adolescence, I want to add to that, into their interactions on the street?
Yeah, I think that, again, to state the obvious, we know that officers factor in that analysis right now, and so that African American and Latino kids are stopped in situations in which white kids would not be stopped. So, again, based on my experience as a prosecutor, I don't think that most cops, that is, are out to get black kids for racist reasons. They're out to get black kids, yes. Why? They often say, well, it's for public safety. So my cop friends say, yes, I enforce the drug law selectively in African American communities, but that's because that's a community that I come from, and I want to take special care of that community. So, you know, if the only tool you have is a hammer, if the only tool you have is arrest, then all of the problems look like crimes, and making arrests looks like the way to solve the problem. So we have to, as a society, as people in the movement say, we have to divest from the police, right? We have to divest from criminal justice responses and invest in the community.
Well, you've alluded to this question about public safety, because I think that is going to be another, pushback. And in fact, it is the pushback that the Massachusetts Supreme Court has gotten. It's that now you are unleashing, black men to run from the police. So the concern is that by taking factors like flight out of the suspicion rubric, that you are creating a free-for-all. How do you help us respond to that? So I'll ask you first, Professor Butler, and then I'm curious, how you all have responded, Justice Hines, to the pushback you've gotten.
There's no relationship between the reasons why black boys and girls get stopped by the police and public safety, or there's a very negligible relationship between those two. So about 90% of arrests, including arrest of children, are for misdemeanors. Misdemeanors are things like jaywalking, like what Emilio was stopped for, spitting in the street, street fights between kids, and drug possession. And when the cops arrest you for that, it's not because they think you're a menace to society. When they arrest black boys and girls from that, they're trying to assert their authority, and they're trying to enroll black boys and girls in the system so that they can keep an eye on them. So it's really an exercise of the state's dominance. Why isn't it about public safety, or how do we know that it's not about public safety? The police have an extraordinary amount of power, and we heard from Emily earlier that they use this power against African American people, especially when they don't do that in situations with white people. So sometimes people say, well, what would the black community look like if the police didn't enforce the laws, if the police didn't try to lock up everybody who they see committing a crime? The answer is it would look like the white community, right? Because that's pretty much what happens with white people now. So also in the movement, a lot of talk about divestment from police, prison abolition. We know what that looks like, because that's the world that many of our white friends live in now. So I don't think it's something that we have to be especially concerned about. What we need to be concerned about at the end of the day is, again, this racialized exercise of discretion by police and how it's not related to public safety. Just to end with a quick story about Wren, the case that Professor Henning mentioned, that says that as long as the police have an objective reason for stopping you, we don't think about, or court shouldn't think about what their real reason is. So to demonstrate the influence of that case, a friend of mine who's a police officer takes my students on ride-alongs where they get in his police car with them, and he shows them what it's like to patrol the streets of Washington, D.C. And he plays this game he calls Stop That Car, which means that the student can pick out any car she wants to, say that silver Camry over there, officer, and the officer stops the car. Now, he's a good cop. He waits until he has a legal reason to do that. It never takes him more than 3 or 4, following the car for 3 or 4 blocks, a couple of minutes. He finds a legal reason to stop it. So that's an extraordinary amount of power. With misdemeanors, as that yellow Camry is to my police officer, black boys are to the cops. So Professor Carbado has another really good article where he talks about misdemeanor and arrest and just lists all of these petty crimes that give the police the power to assert this authority over African American children.
Well, I'd just like to add that as an appellate judge, after having been a trial judge for 12 years, you see more clearly the way that the jurisprudence has developed in a way that abets the bad things that happen on the street between police officers and black and brown persons. And in particular, you mentioned the Wren case. I mean, I think that the Wren case is probably one of the most damaging cases for trying to manage this interaction between police and citizens, because the Wren case says that the police can stop you to get you to open your car so that they can get your consent to look for drugs when they stop you for a traffic violation. They don't have to be concerned by the traffic violation once it's affected as part of the reason for the stop. So police officers are not that stupid. I mean, they understand the power that our jurisprudence gives them when the Supreme Court is saying, as long as they have a reason, we don't care what the real reason is, because it's just inevitable that more persons of color are going to be stopped because of what we heard earlier about they're the ones who are perceived as the criminals. So it's part of the jurisprudence that I think, I don't know that it will ever change, but one of the challenges will be for the lawyers who are out there working hard to find ways to manage these things. That has to be fixed.
Thank you. So even if we can't get all the way to a reasonable black child standard, I do want us to continue to think about ways that we can educate the courts or push our courts to consider race and adolescence in the Fourth Amendment analysis. So I want to come back and talk to Professor Lopez about your previous work at the Department of Justice. You authored a number of reports about police departments across the country documenting harassment, misconduct, and civil rights violations, including in Ferguson. And we'll talk to Professor Hansford about that as well. So part of the success of the racial justice argument, I think in Commonwealth versus Warren, was this data collection. And I want us to think about, if you can help us think about a little bit about, or educate us about your data collection work and your research on police departments, and how can we as advocates use that information in courts?
Okay. Well, first, I would be remiss if I didn't acknowledge that if it takes a village to raise a child, it takes a metropolis to write a findings report.
Yeah.
So there are many of us involved. And also, while I was leading that case and leading the drafting of that document, I want to acknowledge that there are a number of my colleagues here today who are working much more directly on the juvenile justice work, which didn't get as much attention as the Ferguson report, or doesn't always get as much attention as the Ferguson report, but of course is much more directly responsive to the concerns we're talking about today. But I think one thing that's important to think about when we think about using data to speak to the courts and educate the courts is that each of these cases in the Fourth Amendment in general is trying to do two things that are sometimes in tension with each other. One is to help the law decide how it's going to deal with the individual defendant that comes before the court, and the other is how we're going to use the law to regulate police behavior more broadly. And I think we have these prophylactic rules like the exclusionary rule, like the Miranda rule, which Professor Carbado mentioned earlier today, and others. And then we have times where the court seems to take an entirely different tack, like in Wren, and pretend that none of that is related. And so you get this real fits and starts sort of approach to this, and what we have as a result is a system that doesn't really speak to either police practice or dealing with individual criminal defendants in a way that's very satisfying to anybody. And so when we understand that when we are collecting this data as advocates, and certainly when I was with the Department of Justice, that we're collecting that data not only to educate courts, but also to educate communities and police departments for how they want their police department to function. And I think there are just a couple of things that we need to keep in mind when we're collecting that data and when we're asking departments to use that data. One is that you will often hear departments talk about the difficulty in collecting the data. And routinely you will hear, for example, that it takes an hour, 45 minutes to an hour to complete a stop data form. It does not. Uniformly, when you go out and you actually test how long it takes to complete that form in that exact department, it takes you, I've never seen it take more than 2.5 minutes. And usually it can be done in under a minute. That's not the actual problem. The problem is that the department may be concerned, like the Boston Police Department, they don't know how this information will be used against it, which in my view is not a reason not to collect the data. Or individual officers, and I confess to having a bit more sympathy for this concern, they are concerned that this information will be used to call them specifically racist. And I think it's important that we acknowledge that we do need to find out how individual officers are policing, and this data can provide us important information. As a number of the speakers on the first panel, the amazing first panel said, Mr. Bell talked about how this isn't about ferreting out racist actors, it's about deconstructing racist systems. And Mr. McKenzie talked about how John Chisholm talked about this exists, we're going to measure it so we can manage it. We have to really try to redirect officers to understand that the point of this data collection is to fix the entire system, and that we recognize, as Professor Carbado talked about, that the context of how these biases play out is influenced by the workplace. And while we need to bring in officers and train officers so that they do not allow their biases, explicit or implicit, to be part of their policing, we have to also recognize that they're in a system that makes it almost impossible not to develop or act on these sorts of biases. And we own that as lawyers and judges and community members. And so I think the data needs to be able to tell that story. And the one final thing I'll say about the data is that our current AG notwithstanding, I think it's really important to understand that you cannot understand the data divorced from the anecdotal evidence, what some people call anecdotal evidence. To discount the stories of people's experiences, to devalue those experiences and their lives and the harm that these practices visit upon them. And it's also impossible to understand the why behind the data and what we should do about it. So just one quick example from the Ferguson report. One of the things, and I really wish that I had been familiar with Emily Baxter's work at the time, because I would have been much better about articulating this, and we even had a difficult time kind of keeping it in the report because it was so hard for me to even articulate why it was important. But there's a part of the report And no one picked up on this afterwards except for Ta-Nehisi Coates. If one person's going to pick up on it, that's who you want it to be. So that was okay. But there's a part of the report where we talk about, even at the same time that the police department in the city were saying that they had to have this very stringent enforcement of manner of walking and high grass and weeds and, every unbelievable law under the sun, they were writing off tickets for each other left, right, and center. Oh, you don't understand. I had a really good reason for running that red light. Oh, I didn't pay my ticket for this reason. And it really was, for me, it helped me and others understand that this was in part about using their fines and fee system to fund their city. But it really was more, in my view, about imposing a social order over an incoming demographic, African Americans, which had turned their city from a majority white to majority African American, and not wanting to lose the sort of the civic society that they felt they had. And so they really felt that when I do this thing, it's an understandable, okay, forgivable thing. But when you do that thing, that is the first step towards chaos, and we need to nip that in the bud immediately. So it's actually, in many ways, more invidious and nefarious than simply ruining people's lives to fund your city coffers. But you would not have understood that just from looking at the data. You needed those anecdotes. So I think it's really important, as we talk about the importance of data, to also remember the importance of marrying that information up with the stories about what's happening in people's lives.
Yeah. So can you tell us more, for those of us who are advocates in court, and maybe we don't have the Boston report, or we're having difficulties getting the police data from our local jurisdictions? How do we tell those narratives, or collect those narratives, or present those narratives in the courts, or in city council, for that matter, in ways that are effective without some of this data?
So I think that one of the ways we do that is to not forget about the 14th Amendment. The Fourth Amendment is just a difficult posture to try to raise these stories. It's it's a defensive posture. You've got someone who by definition has a gun or drugs or something.
Good point.
You really, cases like Floyd, which is the Center for Constitutional Rights brought in New York, where you can bring those affirmative cases where you can tell the whole story and talk about how this impacts entire communities. I think it's a much more effective way of doing it. And I think that, again, as Professor Carbado pointed out, the law has made it very difficult. And we cannot fix the Fourth Amendment unless we fix the 14th Amendment. We cannot get it raised solely through the Fourth Amendment, in my view. We have to restore sort of the meaning of the 14th Amendment. And I think one of the things we saw from the Muslim ban and the response to that was that still resonates with a significant portion, this sense that we don't want to be a nation that is systemically unequal. I mean, I realize that we're incredibly inconsistent about that, but I think that we shouldn't give up on the 14th Amendment. So I think that's one way is to seek to pair up with organizations that can bring these cases affirmatively, so that when it comes time for your defensive Fourth Amendment case, you can still cite to that 14th Amendment lawsuit. And we actually saw that in New Orleans after we issued our findings report. In that case, defendants in Fourth Amendment cases were citing to our findings report. So that sort of thing is very important. I also think the trick, again, is getting agencies to even collect this data and to analyze it. And so if you're a community member trying to go to your police department or try to go to your city council to get them to collect this data, I think that you really need to recognize that the argument about the time that it takes to complete the data and you won't be able to police effectively if you're spending all your time filling out forms, that is a red herring argument. It's not the true concern, and you have to get at the underlying concern, the fear about how this information will be used, and you have to be able to help them understand that this is information that can help them police better, help keep them safer, and just fulfill their duties as public servants.
So that's definitely helpful, and it certainly speaks to this the notion of the importance of marrying our individual advocacy with some broader class action work or some collaborative work, which takes me to Professor Hansford, who has been a leading activist in Ferguson, and I wanted to ask you to talk a little bit about how to bring about reform in policing and reform. It's a big question, right?
Right.
Reform in policing through community activism. So how do we marry sort of our individual Fourth Amendment advocacy with some of the civil rights litigation with on-the-ground community activism?
Woo. Well, well, first I want to say that I loved all the presentations. Going back to Ta-Nehisi Coates again, he made a statement one time where he said that the interaction between the police and the everyday person on the street, the citizen, is the first time for most people that they have an interaction with the state, with the government. So these harsh, punitive interactions that young people are having with police are then framing how they look at the United States of America and their place in it as young African American people. So it's a fundamental question that speaks to our democracy. And I think that all these points that were made today are important because as we think about the advocacy and especially thinking about the kids, you are shifting their worldviews and you're creating an opportunity for them to either see their life as something that's full of possibility or something that's inevitably going to lead to being dead or in jail. And so in Ferguson, when I think about times out there facing tear gas and all these things, one of the reasons that you had young people willing to go to that length is because many of them, if you talk to them, they would say, based on our interactions in Ferguson or in the St. Louis area, it's inevitable. We know they're coming for us. We know they're gunning for us. So why not at least rise up and be able to exercise some sort of defiance before it happens? So if you look at places like Chicago, you look at things happening around the country with black youth, it's that sense of hopelessness that is constructed by these sorts of interactions with police that then leads to more destruction and violence and acting out. And it's something that you can see again in the policies. I like the thrust of your question, how can we merge our advocacy with things like class action lawsuits? And, of course, in Ferguson, we've had our consent decree process, and Professor Lopez's work has been so important for that. Actually, it was a student in one of my classes. I taught in St. Louis for the last 6 years, a critical race theory course. And one of my students, she was from St. Louis, and she had a cousin who grew up in the city schools. I don't know if any of you are familiar with St. Louis, but there's a big divide between the county and the city, which is almost completely a racial divide. And so she compared the student disciplinary codes of conduct from the two school systems. She found that for the first act of disruptive behavior in the classroom in the city, you would get a minimum of 3 days suspension. In the county, where there are less minority students, after-school detention is the most you can get. And it was right there in the code of conduct. Now, the reason she decided to undertake that project, there wasn't data out there that she was able to survey in the beginning. She had a young person, a teenager who was her cousin, who said, go look into this. We all know that they're treating us differently based on race. And so the kids know this. And there's that saying that, kids, they may not listen to anything you say, but they're watching everything you do. Mm-hmm. They know that these disciplinary policies, the police behavior is based on race, and it's driven by race. And as that continues day after day, year after year, it gets to the point where you can't really make a moral distinction between the police or the local gangs, the Bloods or the Crips, all these different groups that are confronting you, that are trying to intimidate you, that are using violence to do so. If we were going to distinguish police intimidation of black youth from the gang intimidation, you would say, well, at least the police are trying to do the right thing. They're trying to uphold the law. But then once we've proven through data or through anecdote that they're not upholding the law, they're upholding racial hierarchy, there's no moral distinction. There's no moral distinction. And once you get to that point, then you can have situations like Ferguson where the youth feel like they are justified in their defiance. And to be honest, most people in the community, if you really ask them, to be honest about it, maybe they are justified in their defiance. Once you've completely lost, your justification. So there's a book that I wanted to recommend to people called The Hate You Give by Angie Thomas. It's a pretty new book that's come out recently, The Hate You Give by Angie Thomas. And she talks about, it's a fiction book, but she really delves into the psychological dynamics that the youth are experiencing while they're seeing these videos, while they're hearing about these reports, while they're watching these memes, and they're seeing their friends being caught up in this system of mass incarceration, unlawful use of force that is taking their lives away. And they're having to create their worldview as young people, and this is going to stay with them for the rest of their lives. And we have to start thinking about what sort of mental world, is being created in the minds of our youth who are having to experience this type of mass incarceration-based policing.
Just excellent. I got to say, circling back, I love your story about how the law student used that research or found the research on disparate treatment and discipline. For me, it just shows what one person can do wherever you sit within the system. And so I'd love to roll back and just hear a bit about who what stakeholders did you engage with in Ferguson? How did your movement start? I mean, Ferguson started because Michael Brown was killed. How do we start a movement around that and get at these narratives without a Michael Brown dying?
Right. Well, once Ferguson happened, there were a number of factors that led to that, right? So one of the factors was the vacuum in civil society, to be honest. And so the traditional establishment organizations that might have decided to have a meeting behind closed doors, or might have decided to sit down and have some sort of more reserved hush-hush discussion, those weren't present in Ferguson. So it was left to the town hall, and it was left to the youth to lead lots of this activism. And many of the people in Ferguson who led that response never became famous. One of them worked at 7-Eleven and went back to work at 7-Eleven afterwards. Some other folks continued with their activism, a handful of folks. But for the most part, it was everyday people that were willing to go to town halls, that were willing to speak out, and folks had to listen because of the nature of the response. I mean, it's hard to recreate a Ferguson. There's a number of factors. I tell people, Mike Brown is such a unique thing. The narrative we had was that he was killed. Some people say his hands might have been up, maybe not. But the iconograph of the hands up, don't shoot, it was something that captured people's imagination because, for many people, it was a demonstration that the black youth are not always the people who are beginning the violence. Sometimes they're on the receiving end of the violence. And so it sort of flipped the traditional stock narrative of what it means to be a black youth in America today. And it was something that was, if you had hired an advertising person and said, come up with the easiest, most catchy thing that you can think of and an easy symbol for people to adopt. 10-year-olds were running down the street saying, hands up, don't shoot. And if this was his last act as a person on this earth, to put his hands up and to say that phrase and for it to be something that caught on all around the world and that helped to spark a movement, is really a spiritual sort of thing that happened. So it's hard to recreate that. I don't think that can really be recreated.
We want to in that way.
Right. But I do think after that happened in Ferguson, we saw the local city government leaders come to the table. They were forced to the table. We saw local civic society leaders, pastors came to the table, youth advocates came to the table, lawyers came to the table, professors came to the table. And so you needed involvement from all different sectors. I think sometimes folks in the advocacy community think that they can do it by themselves. And, it's all right to have confidence in your skills, but I think you need to have community engagement from many different areas of life in order to create significant change. I can't say that in Ferguson we've created widespread change, but we know that we have a new prosecutor in the city of St. Louis that was someone that the activists pushed. We know that we've had the consent decree process begin, and we've had a desire to continue to be engaged in that. But we've also had Ferguson activists killed, Darren Seals, Edwin, the young man who was in that iconic picture throwing the tear gas canister, wearing the shirt with the American flag on it. He was recently killed. So we've had tragedies and we've had victories. So I can't really say Ferguson is a success story.
Right.
But it is a story of people that were fed up. And I think after almost 3 years of studying it, we're starting to realize that not only were they justified, but it's something that is potentially possible all across this country. And I think people are responding to it appropriately.
So I definitely think Ferguson, if anything, is a story of collaboration. And so what I want to talk about next is collaboration across the lines, not just within the advocacy community. And you got to that, this notion of we've got to collaborate with other stakeholders. And I think it's been said more than once today that most people, most stakeholders, whether they're police officers, prosecutors, defense attorneys, judges, nobody wants to be biased, right? People, generally speaking, don't want to be biased. And so I want to talk to Lisa Thoreau about working at this question from a different angle, which is the angle of collaborating with police officers. So I wanted to, I'm going to pull up, she has PowerPoints for us. So what I want to do is to get you to talk a little bit about your organization, Strategies for Youth, and how you work with police departments across the country to address some of these issues. Can you first just tell us a little bit about your organization?
So,
and let me do this. Can I give you the...
I was wondering, thank you.
Put you in control.
Oh, I like that. So I'm very delighted to be invited by Kristen, who I admire, and grateful to be at a law school that wants me to speak, because I am a lawyer, but I really enjoyed only about 47 minutes of law school because my background is political anthropology. And going to law school after political anthropology was like leaving a bright, sunny July day at the beach and going into a movie theater where nothing was playing and there were no lights on. And I say that because throughout my law school career, I was astonished at the absolute rejection I saw in judges' understanding of reality. And to me, if you wanted to assert hegemony, that was the way to do it. Just ignore reality exists. So I'm not a good lawyer, I guess, because of that. But I did learn how to sue people when at law school, and that's helped me tremendously. So, and I like it. So Strategies for Youth is a national nonprofit policy and training organization dedicated to equipping officers with best practices for working with youth and reducing disproportionate minority contact. And this organization, which formally started in 2010, was born out of a lawsuit I brought against the MBTA Transit Police in Boston, who in 1999 were arresting about 646 kids a year. They were major contributors to DMC in Boston, and by the time I got done with them, we were down to 84 arrests of juveniles in 2009 and keeping it under 100. We do three things. We train law enforcement officers in policing the teen brain. We do a lot of outreach to youth with juvenile justice jeopardy. And to answer the question about what's a reasonable child, I just want to show you a question that a group of youth in a nearby city asked us to prepare for the game. They wanted this question: may an African-American teen walk through an all-white neighborhood on the way to a public basketball court? And the answers they wanted us to use were A, it is criminal trespassing if he or she does not live there. B, it is no problem, streets and sidewalks are public. Or C, if it isn't the fastest route, it is considered loitering. And after we developed the questions with the youth, we actually went and played it, and all the kids said A, it's criminal trespassing, because that was their lived experience. We also do policy and outreach. We've done If Not Now, When, which documents the abject absence of training of law enforcement
for dealing with youth. First, Do No Harm, which aims to provide policies to law enforcement to reduce and mitigate the harm kids experience at the time of parental arrest. And finally, we're coming out in 2 weeks with Where's the State, about the abject absence, you'll hear this theme, of policies or any model policies for law enforcement to follow when it comes to youth handed down by the states. I want to talk about 4 structural factors, if I could, that we try and address when we work with police departments. And the number one is, and all of these are rooted in my belief that they are the sources of these problems, is deployment. And when you look at how police are deployed, and you combine that with the absence of training, and you see that there are often policies or standards only for adults. In fact, we're working with a large city right now that didn't have a single policy for dealing with a juvenile. And then you see that there are no oversight mechanisms. You see why we're in this fine mess. Is it all right if I keep going? Yeah. We know arrest is the greatest source of disparity. So using white youth as the reference, the relative rate index shows the greatest point of disparity is at the referral stage or arrest. And we also know that officers are deployed in a way that they are disproportionately focusing on poor kids of color. And we see this in schools, we see it on the streets. Our study of training showed there isn't any. 6 hours or 1% of academy time in topics like juvenile code, nothing on mental health, nothing on the Juvenile Justice Delinquency Prevention Act, demanding that law enforcement agencies address disparities in arrest. The International Association of Chiefs of Police looked at what in-service training was being provided in 2011 and found nothing was offered there either. So officers are not trained in what they ought to be trained in, and frankly, not are a lot of school folks either, on brain development, on developmental competence as we've defined it, implicit bias, mental health. 1 out of 5 kids during adolescence has one issue or another. And if you are a parent of a child who's an adolescent, you would argue that the rate is higher. No one is taught about alternatives to arrest or the impacts of arrest or community resources. At the policy level, there aren't any. How is that possible? There aren't any. There are no standards, there are no statutes, there are no regulations in 46 out of this nation's 50 states. Individual departments develop their own policies and practice. They may use the International Association of Chiefs of Police or the Commission on Accreditation of Law Enforcement Agencies policies, but there are no national or pre-existing policies, and there's no obligation to upgrade or update them. So that is a lot of what we do. And here are the findings from our forthcoming report called Where's the State? This is unacceptable, and this is something we must advocate for. Look at this. This is too yellow, right? This is inadequate, even in the blue states. We hear the IACP saying we have to train and use developmentally appropriate responses to youth and develop protocols, but they are slow at it themselves, and frankly, they supported the appointment of Mr. Sessions. So all they're saying about equity and policing is hard to understand in the context of that choice. So when you look at oversight mechanisms, the incredible work of advocates and youth who said this is unacceptable is key, as are the role of individual attorneys. But frankly, there's little else right now. You had the U.S. Department of Justice under Loretta Lynch, Eric Holder, and President Obama doing a phenomenal job, and hats off to Christy Lopez and her colleagues there. But we even had to argue with some of the consent decree language in Cleveland and Ferguson for not mentioning youth, for not doing it sufficiently till Baltimore. And under President Trump and Mr. Sessions, there's no hope, in my view. So just getting right there.
How do you feel about that? No.
Yeah. Glad you asked. So what we're trying to do is look at some of these structural issues. We write the policies for police departments. We incorporate how a traumatized, responsive children will affect their behavior, and that police must understand that. We recommend that if you have a traumatized response and you keep seeing disorderly conduct and resisting arrest, that's time for you to review what your officers are doing, not to imprison more children. And there are departments that do that, that have double rows of supervision and inquiry about that kind of charge. Through our Policing the Teen Brain training, we're trying to affect both structural and attitudinal change by introducing officers to the teen brain, such as it is, prevalent adolescent mental health issues that really need to be understood, and trauma. Many officers are traumatized, and they come to understand, we find them getting very silent during the trauma section, how they're behaving too. The second day, so day one is the brain, day two is the environment, or day one is the Jello, day two is the Jello mold. We're talking about demographic and cultural factors, and 9 times out of 10 we're told, I had no idea these kids are so poor. Well, yeah, maybe that's why they stole from the lunchroom. We talk about development in the courts. They are not trained in juvenile law. They don't know about JDB. The North Carolina city that brought the JDB case did not know the decision had been handed down. So when we play Jeopardy, it's a good opportunity to train some law enforcement what the laws are, remarkably. And we talk about how to assert authority effectively, and then we bring in youth and have them explain why they're likely to comply or not with police. And our premises are adult criminal justice system approaches harm youth. It's not that they're not appropriate, they're harmful. And if you have some degree of developmental competence, and you understand that youth perceive, process, and respond differently than adults, you'll interact with them better, and that you're better off using your community resources to provide alternatives than to arrest them, because you as officers are just as frustrated with the juvenile justice system as those of us defending children in it. We really talk about procedural justice quite a bit, and if you see on the bottom right, there's a section on predatory policing. So one advocate said, oh, Lisa, you really try and get hated, don't you? And I said, no, I don't have to try. You're going to really get it head on for saying don't be predatory by the police. Not a single police officer has challenged us once, because they know exactly what we're talking about, that we are talking about those instances when they exploit a 12-year-old walking home alone, and 3 of them jump out on them. When a 15-year-old is walking home alone and they ask them, what do you have in the hand, and slap it out when the kid says, it's my sandwich from my grandmother. They know what we're talking about, but we have to get them to stand up to the officers in their departments who do that and say, you're ruining it for all of us. They're not doing that enough. And Laquan McDonald is a great example, and let's not forget that in Tamir Rice's case, not a single policy was violated in that police department by the officer who shot the 12-year-old to death. Interactions with police are a developmental milestone for boys of color, a fact about which I'm deeply ashamed about the United States. It means in Louisiana that you get arrested for not walking on the sidewalk, and the court will proceed with that even though there are no sidewalks. It means you accept that as part of what it is to be a black boy. And as you've said, Kristen, and I hope you don't mind my quoting you, it's...
I did not plant this.
What you see with a lot of boys is, oh, he's just a boy, right? It's okay, but black boys don't get that mitigation. So when we talk about implicit bias, we don't go head on because it's painful, and it leads to such reactivity. As I was just telling folks yesterday, I was told by a group of police officers in Northern California that there is no racism. Good to know. Shall I leave now? And that there is no bias, and they don't have bias, and they feel bad for the black woman who presented to them on this topic, that she feels that way and doesn't understand that everything is justified. We've got a terrible row to hoe on this. So we use a lot of oblique tactics that I don't have the time to talk about. But in answer to your question, yes, black boys are a unique demographic group. I think officers assume that they're savvy, they assume that they're criminal, they assume that they're dangerous, they assume that they need to be subjugated and taught a lesson about where their role is and where their status is in this social hierarchy. And because no one's truly invested in these kids, look at their families. You see the perfect intersection of race and poverty justifying, in a system with poor controls, little oversight, and no training, mistreatment of boys of color. So when we talk about deconstructing the process of bias, I'm really thrilled to hear people using the thinking fast, thinking slow thinking, because that's exactly what we're paralleling. We are saying if kids' amygdala is fight, flight, freeze, and it's the fast part of the brain, and it causes us to regret a lot of what we see them do, that's how we want to understand bias. So if you have an incident and your frontal cortex is working, if we're lucky, you're going to be deliberate. You're going to consider the facts, unlike law school and judges. You're going to make a decision based on facts, and then you're going to take action. But a biased person who's unaware and reactive acts like the amygdala. So I see something, I'm going to ignore the facts that contradict it in the context, and I'm going to react and take an action that's harmful. And that's what's happening with too many law enforcement people and the rest of the adults in the systems who call police to deal with kids. The essence of innocence is something we teach officers all the time. We always talk about this. We always bring it up in the context of Tamir Rice. I've got to go quickly, I know. But Tamir Rice was 12 years old when an officer drove 25 miles an hour through swing sets to kill him. And the first thing he said is, "I've got a black male down," and he's 20. And no policy was violated. Contact matters. There's great information out there from Wiley and Finn Esbenson and Tyler and Fagan about if simply being stopped and questioned has deleterious consequences, policing practices may contribute to even higher levels of delinquency even before youth have reached the age of formal processing. Why? Because if you're being treated like a criminal before you are, what's the disincentive to not offending? It reduces in proximity to your first thoughts. So these research articles are phenomenally important, I think, for defenders to consider when bringing defenses of kids who have been treated this way repeatedly. So we urge officers to always understand that the way kids will respond to them is to determine if they are a rescuer or an abuser, and too often they don't see them as anything but abusers.
So thank you. Actually. You covered everything that I wanted you to cover. I think this is excellent. This is, been an hour-long conversation that could go on for a day easily. We've talked about litigation in individual cases. We've talked about judicial courage. We've talked about class action. We've talked about community activism. And then we ended with a conversation about training and collaborating with officers. So we have just a couple of minutes. I did want to see if anyone in the audience had a question for one of our panelists. You can come to the microphone. That would be great.
I think it's a bit of a statement. If there is a reaction, would it be appreciated? There's been a tremendous set of contributions from all of the presenters. One of the things that I think lawyers have often shared in representation of children is the need for hoping that children get justice, but I'm also hoping that we appreciate the need for healing in the work that's being done and representation of children. I think, Professor Hansford, your comment of how the youth in Ferguson were willing to just sort of march into the face of what seemed to be fairly negative outcomes, and it reminded me of war film clips where you'd watch officers say, "We have to take that hill," and they recognize that many of those people who would be taking that hill would die. When children are at that point in life, we can't just get justice for them, by helping that their case will come out, have favorable outcomes. We've got to do some things recognizing that where these young people are now, they just don't feel cared about. So I hope that we also take from these conversations the need not just to represent, but to help young people heal.
That's excellent. Winston, I saw you come from the balcony. Did you have a question? No. Okay. She had told me earlier she had a question for me. Any other questions? Dare I say any other questions? Yes, please come to the mic. If you.
Absolutely, and look us up online, strategiesforyouth.org. There's a phenomenal interview of Dr. Richard Dudley, a psychiatrist from New York City, talking about how racism and sexism about black boys collide, and what his recommendations are for law enforcement when those two collide. It's really a beautiful interview based on an article he wrote, strategiesforyouth.org.
Excellent. And one last question. That'd be awesome.
So it's great to be back here. I'm a Georgetown alum. It's great to, Paul Butler was my professor when I was here. So my question, when it was concerning when we were discussing movement building, and how do we get this started in this day and time? And my initial reaction was like, how do we balance the decision of not choosing to emphasizing the longstanding documented brutal history of the police state and its relationship to communities of color, which is harmful to movement building, being that, you know, this new influx of like police brutality is actually not new, and that the Black Panthers were the Black Panthers for a reason, and that in the South we had long-standing community watch groups that watch police officers, so it's actually not a new thing. But how do we balance kind of like de-emphasizing that truth with building partnerships with people whose job is to, well, whose job may not be to uphold white supremacy, but who in its action does uphold white supremacy, i.e. the police and prosecutors. So how do we produce a movement when those are our partners?
Which is a phenomenal question. I'm just going to tell you, I only have like a minute or two. We keep giving you the hard,
Somebody else
big
wants to
questions.
jump in as well on this.
Yeah.
I say don't. I don't think that, like I said, when I was thinking about community partnerships, I was thinking about the faith community, I'm thinking about the nonprofit community. I think you have to be very careful in light of what the gentleman said as well with the mental space that Black youth have to occupy. It is a big hill to climb to think that those same police officers who have been in an abusive relationship with them their entire lives are going to suddenly be accepted as partners, and you can create some sort of community policing solution where they can come play basketball and it's all over. Some people will think that, but other people will think, well, the more contacts, in fact, Professor Carbado has taught us, the more contacts that these youth have with police officers, the more likely something is to go wrong, because there's more of a possibility for escalation. Police officers have guns all the time. So I don't really think that the answer is community policing or increased contacts or increased partnerships with police or prosecutors so that you can convince them to start having better attitudes about the youth. I think the answer lies in increased partnerships with, like I said, faith community, perhaps lawmakers, perhaps other civil society actors who can then start to change the political atmosphere so we can change the way that we police these schools and these kids.
Thank you. So thank you again to all the panelists. And let me invite you to join us in the next building over. There will be people to guide you over, but we have a complimentary lunch for everyone. And even if you need to make some phone calls and the like, I encourage you to go grab your lunch and take it, sit outside. There's tables and the like for you. But please go and get lunch. We will come back here at 1:45. We will come back here at 1:45. And again, I really encourage you to come back. We've got a young person who was previously incarcerated and then later exonerated, and he's got a powerful story to tell, plus the rest of our afternoon session. So we'll see you back here at 1:45. Thank you.
They have a fellowship for Ferguson.